unlisted item, but my lord, my ill fate, my lord, because there was some defect in the read petition and actors were not eligible, my lord. By the time I rectified the defect, it was already 4 o'clock. May I seek permission to move it today, my lord? I tried my level best, but before 4, I could not do it. By 4 o'clock, the defects were rectified.
Bring it.
For listing admission matter, next week any day.
Not next week, after that. 19th?
19 malad.
19th?
Malad. 19. If possible, malad.
14th?
14.
14th? This to update us, na?
14.
14th.
Two matter, malad.
What is the subject matter?
Subject matter regarding malad, 3 persons died in the malad water supply tank. Accordingly, malad, we have
Ex-gratia.
ex-gratia.
Both the matters.
Yes, malad.
I beg to listing of a case for admission. Ex-gratia
Ex-gratia. Same date, 14th.
14 obliged. Made Procedural. My lord, I pray for adjournment of item number 57 of today's list. After
57.
taking consent from the other side, I'm mentioning.
You are for the petitioner.
Yes, your lordship. I have received a copy of an affidavit from the other side. So I like to file a reply, your lord.
Item
Matter come next week.
57 at the request of learned counsel. Petitioner.
There's an interim order.
Matter stands adjourned for 2 weeks.
Hello, can you please after 1 week, madam? Because there is some item.
After 1 week. The counsel for the respondent does not object to the interim order. If any passed earlier, will continue.
Highly obliged.
Your lordship, I like to mention for admission. Last posting, my lord, 26/4/2024.
What is the subject matter?
Ex-gratia compensation matter.
14.
Lordship, another also same.
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 14 June.
May I please your lordship?
Yes. What do you want?
I beg to mention for listing. I beg to mention for listing for admission.
Subject matter
Payment of ex-gratia relief.
14 June.
Lordship, I am for 61, my lord. My lord, matter is
Who is for 60?
For 60.
Learned counsel for the parties submits that the petitioners do not wish to press the petition any further and therefore seek to withdraw. The same accordingly, the same stands dismissed on withdrawal. Interim orders, if any, stands vacated. MSM Gorman appears for the respondent.
Okay. My lord, there's section 11 application on the arbitration. Notice may be issued.
Third learned counsel for the parties issued notice. Returnable 3 weeks. Steps on respondent by usual course and registered post within a period of 1 week and today.
Deeply.
Mr. G. Rahul for the petition.
Wait, this is your lordship. Lordship, may kindly pass it to the matter for the binding.
Time being. You want time being?
This time, notice may be issued to the respondent.
What is the issue?
Issue lordship, this respondent has acquired the land of this petitioner, but without paying any compensation.
All right. Third learned counsel for the parties. Issue notice returnable 4 weeks and it's learned.
I'm appearing for
Departmental
2, 3, 4, and 5.
Respondent number 2, 3,
3, 4, and 5.
2, 3, 4, and 5. Who's for NHIDCL? Anyone for union? Mr. You are there? Yes. MS A. Pugan appears for respondent number 1. And MS. Yes. Who's for NHIDCL? Who's the
Actually,
counsel?
C was there.
Mr. C. Borwa. Appears for NHIDCL. Counsel. You have served copies. The council's representative the respondent. This is the way the copy be furnished within a period of 1 week from today.
Deeply obliged. It has become infectious, my lord. I have challenged the order at page 40, my lord.
Hmm.
Subsequently, my lord, they have withdrawn this order, my lord.
It has become infructuous.
Infectious, my lord.
Learned
With
counsel
liberty, my lord, may be allowed.
submits that the writ petition has become infructuous. Therefore, the 6 to he does not wish to press the petition any further. Accordingly, the same stands dismissed as not pressed.
However, Lord's liberty, my lord, if any further action that takes, I can come back again, my lord.
Needless to say, petitioner the liberty to approach the court in the event of any grievances which may arise against the which may arise in respect of the same issue. You are appearing for respondent. MS K. Pupan appears for respondent number 1. Who's for GST, Mr. KL?
Mr. Kalis there.
For respondent 234, Mr. KL appears.
Obliged, my lord.
Yes.
May I please, your lordship? Lordship, this is relating to lordship cancellation of lordship GST registration of the petitioner. Lordship, the order, impugn order, yes, is at page 47. Lordship, my main contention is that the SOCOS notice which is referred to in the lordship order, I have never received even till today because lordship it is self-generated, but I have not received this notice till today. And lordship, so therefore I could not reply. Lordship, I filed an appeal that is also been rejected by page 60, lordship. So my humble submission is lordship that lordship, there is no use lordship because I'm doing a business and there is no liability of tax as such lordship. At page 47, lordship will see that there is no liability of tax. Only it has been rejected for non-submission of returns. Lordship, in similar cases, lordship have already held that the returns we may file and accordingly, lordship,
I will have infraction.
You want to instruct?
Yes.
Heard, MS and Novelia, learned counsel petition, the Gugoi for the respondent.
1, 2, 3, 4, all.
Respondent 1, 2, 3, 4. The grievance of the petitioner is the cancellation of its registration, GST registration. Stop appeal filed against the cancellation is also dismissed. Submits that the notice prior to cancellation was not received by the petitioner.
similar matter, lordship, on 14 June.
Would you receive
Counsel
it?
for the respondent submits that he would like to complete his instructions in the matter. Therefore, it is still no notice is issued. Let the matter be listed on 14.
14 June.
My,
Meanwhile, the petitioner will furnish extra copies to the counsel for the.
But in fact, Madras High Court has held that it amounts to capital punishment.
Why?
Lordship, the cancellation of registration because because the lordship, the businesses of the petitioners are getting closed down only because they have not filed the returns on time.
That's
That
the
is
mandate of the act.
mandate of the because of the statute, lordship. Otherwise, even the officer does not want to cancel it.
That you challenge this statute. Why haven't you challenged? Yes, 14.
Lordship.
Kindly talk about the letter of family.
6 to 10 are similar matter.
Hmm?
6 to 10 are similar. But
Similar for what?
regarding
These are what?
challenge of limitation, my lord. Regarding extension of limitation for issuance of order under section 73, my lord. Lord,
Is that force majeure?
Yes, my lord.
Force majeure.
Yes, my lord.
When are the other matters fixed?
My lord. The notice was issued on, my lord, here 22nd May, my lord. It was returnable for 4 weeks, my lord.
It's only on this issue of what is a force majeure, but whether it includes Mr. Gogoi will issue notice at this stage.
Yeah, we only noticed one. Similar orders, Lordship has passed. I'm paying for similar leave.
Heard learned.
Okay.
We have passed some orders
One.
directing no coercive action.
Okay.
Same order.
It may come along with this case, but no, I'm not
Yes,
fixing
yes,
it.
yes. It is mapping on 25th of June. 25th.
My lord.
I should also enter this along with WPC 2566.
Completely obliging.
Similar
My lord, 6, 7, 8, 9, 10 are similar, my lord.
5, 6, 7, 8, 9, 10.
My lord, 6, 7, 8, 9, 10.
6, 7, 8, 9.
My lord.
6, 7, 8, 9, 10 to be listed together.
Deeply obliging, my lord.
25th. Yes. Mr. Gogoi.
May it please, Your Lordship. My lord, in this case, the petitioners are resident of Chandrapur area, my lord. Then petitioner is the patadar, my lord. His land was transferred by somebody, my lord. Do not know anything. Then his name was purchased by one Pavan Sharma, my lord. Then his name was mutated after first purchase. Thereafter, the particular government officials, he came to know that this is a tribal belt area, so it cannot be transferred. So his name was deleted. Thereafter, he went to the Honorable Assam Board of Revenue. Revenue Board, my lord, without considering anything, set aside that order. Thereafter, again, the name of the particular patadar was mutated again. So, and these petitioners came to know only on 2019 when this land, when they after their death of their father, they went to mutate their name. Then he came to know that the heirs of Pavan Sharma also filed an application for mutation. So, the learned SDC, my lord, matters are pending for mutation cases, their petition and other petition. And in the particular land, my lord, there is a brick field is going on, and the petitioners are getting some remuneration from the brick field, my lord. They are under the impression that the brick field was given under lease by the father. Now, my lord, under the law, your lordship may be pleased to see page 7 of my petition, that in tribal belt, my lord, no other persons except tribal or resident of that locality, my lord, cannot purchase any land, cannot mutate. So, as such, my lord, your lordship may be pleased to see, SDO, my lord, correctly, we cancel the mutation. Your lordship may be pleased to see page 40. Page 40, Annexure 5, my lord. This case relates to the mutation of the name of the Pavan Sharma within tribal belt of Chandrapur circle under Pragjyotishpur subdivision. The notice was duly served on party. It appears that the party has been heard at length and has submitted documents. It appears that Pavan Sharma has not been able to produce any valid documents proving that he is a permanent resident of the tribal belt. Moreover, as per amended section 164, chapter 10 of Assam Land and Revenue Regulation, even for a person who is a permanent resident of tribal belt block area but does not belong to a class of people under section 160 of the chapter 10 of Assam Land and Revenue Regulation, explicit permission from DC is required. Accordingly, my lord, last line, my lord,
C. Pavan Sharma is not a member of any protected class and mutation granted to him without deceased permission or violative of section 162(2) of chapter 10 of Assam Land and Revenue Regulation. Accordingly, my lord, the next page, my lord, in the SDC's report of so dated the document submitted by Pavan Sharma, no satisfactory explanation has been submitted by Sri Sharma. Then below, my lord, ask the SDC to correct the record accordingly by returning the name of the original patadar and to send copies of the corrected records to this office within 2789. Against that order, my lord, the said petitioner, my lord, went to the before the Honorable Assam Board of Representatives at page 45, my lord. 10-3-93. Where is the petition? The case of 21 RA and also order dated so-and-so, case number so-and-so. Hard learned advocate for both the parties. The SDO has issued a notice to show cause on 7789, but without waiting for that, he had passed an order on 4789, which is irregular. Secondly, it is seen that he had passed the order under section 151 of Assam Land and Revenue. That is absolutely wrong, madam. Earlier, my lord, I read, my lord, that this order was passed under section
Is page 42 order,
165.
page 42 order.
Yes, 42 order.
Now against this, have you filed an appeal or you filed an appeal?
Again, my lord, after Assam Board of Revenue, because the petitioners did not know anything.
So this
about
is,
this.
this is by SDO. Page 42 order is by SDO.
Yes, 41, my lord, subdivisional officer. He has the power, my lord. Then again, my lord, the name of the Pavan Sharma was mutated.
Wow.
Thereafter, my lord, everything was there, my lord. Pavan Sharma died in 2010, and there is a repeal running on over the land, this particular land, my lord. And the petitioners, their father, are getting regular amount from the brickfield, my lord. They were under the impression that the land was given on lease, my lord. Now, when they, after the death of their father in 2019, when they went to the SDC's office, my lord, of Chandrapur, they came to know that these things, everything they, after collecting this record, as there was no other alternative, they have filed this application, my lord. Your lordship may be pleased to see page 32. That is the notification of the tribal bill, my lord. Page 31 is page 31. Page 31, my lord. Revenue Settlement Department dispute protected belt and blocks in Assam. Then next page, my lord. Kamrup, clause number 7, my lord. Sonapur Circle, Chandrapur, and Palakkari. So, my lord, under the law, my lord, a person, SDO correctly passed the order because outsider, my lord, are not allowed to purchase the land of the tribal bill. Even he is a resident of that, he required permission, my lord. Accordingly, my lord, the SDO correctly passed this order. But the revenue board, my lord, taking this order as under section 151, without considering these things, my lord, without hearing the petitioner, without hearing the concerned authority, my lord, set aside the order.
By which order? By which order? Where is the order of the revenue board?
Revenue board's order, my lord, I have just now read, my lord.
Page number
Page number, my lord.
34.
This is 10-3-93. Petitioners were totally ignorant, my lord. He is a illiterate person, my lord.
Yes,
Sir,
yes.
the petitioner.
Where is the order of the revenue board?
Revenue board, page 45, my lord.
45.
Page 45.
Last column.
It starts from page 44, my lord. Last, my lord, here. 10-3-93. Without waiting for that, he had passed order on full. That is totally wrong, my lord. He was given notice, Pavan Sharma was given notice, asked to show cause that he is the resident of that particular area and he is a tribal. But he failed to produce any document, my lord. He purchased, and this sale deed was also, my lord, actually, at that time, the petitioners did not know anything. Some fictitious person, my lord. He sold the land. These things are to
But
be,
you have filed a title suit, haven't you?
no, my lord, because at that, presently, my lord, came to know, at present, my lord, they prayed for mutation of the name of the heirs of Provincial. And their name
Order
should
of
be,
93. Order was passed in 93.
yes, my lord. But knowledge came only recently, my lord. After the death of their father. And if it is passed in 1903 also, my lord, the SDO has the full power to cancel that. Because your lordship, under the law, my lord, this is the Assam Land and Revenue Regulation, my lord. Here,
Yes,
60
let us
164
hear
page, my
the
lord.
respondents. Let us hear the respondent. Yes, madam.
One of the ground is delay, my lord, and otherwise the response are required, my lord, for notice may be issued in that purpose.
All right, heard learned counsel parties issue notice. MSM Vermont. Learned cabinet advocate accepts notice on behalf of 2, 3, 4, 5.
IPF one.
Mr. A. Bhattacharya for respondent 1. Steps on respondent 7 and 8 by usual course and registered post AD. Since the government councils appears for respondent 1 to 6. Sorry, 1 to 5. No notices are waived. Call for. No notices are waived. However, extra copies be served within a period of 1 week. This after returnable date.
My
Yes.
lord, only, my lord.
Hmm.
Your lordship may be pleased to see page 29, my lord. During this period, my lord, let them so cause, my lord, they have, actually, they are in my favor, my lord. Further proceeding of the, my lord, this Assam Board of Revenue's order and the mutation cases may kindly be stayed.
Mutation cases have already.
No, my lord,
What orders?
nothing concrete was passed. Only, my lord, the hearing started, my
All
lord.
right,
So,
we
so then
make
another thing.
it returnable 2 weeks. Issue notice on the interim prayer. We'll consider on the next date.
Yeah.
After service of
2
notice.
to 5, I am appearing, my lord. If necessary, record may be called for the Board of Revenue.
Not necessary now.
Right.
You're appearing for 2 to 5.
5,
Yes.
my lord. 6, I
List after 2 weeks. Private respondents, Dusty is also particular. You take steps on the private respondents. Yes.
Okay.
My lord, petitioner before your lordship, my lord, is a proprietor, my lord, of an pre-clean industry, my lord, namely GPS Enterprise, my lord, in the Nalbai district. My lord, what happened in this case, my lord? After all the formalities, observing all the formalities as well as obtaining necessary permission from all the concerned authority, my lord, while the petitioner had already completed the, my lord, construction of the pre-clean industry, my lord, particularly from the consent to establish from the Pollution Control Board, Assam also, my lord. Now, my lord, suddenly, my lord, what happened, my lord, the chief commissioner, my lord, had issued an prohibitory order, my lord, to restrict the transportation of, my lord, heavy vehicle. Subsequently, my lord, they had, my lord, sealed the premise, my lord, without issuing any show cause, my lord. Kindly come to page 40, my lord.
Restriction. Yes.
My lord, yes, my lord. And to Parvin Sultana, their petitioner before your lordship, my lord. Subject sealing of the premise of pre-clean GPS Enterprise, my lord. With reference to the subject cited, I am to inform you that as per direction of the additional district commission, Nalbar by letter number 750, dated 2/3/2024, we are to seal the premise of the pre-clean MS GPS Enterprise on 3/3/2024 for violation of the Assam Pre-Clean Establishment Regulation Rule 2023 by Parvin Sultana and Zia Pasha. In regard, you are requested to cooperate with the undersigned. Here, my lord, while they are referring to the, my lord, Assam Pre-Clean Establishment and Regulation Rules, my lord, 2013, my lord, their tool, my lord, so far, my lord, no knowledge is concerned, my lord, I have checked also, my lord, their tool had never published in any gazette, my lord. that is not effective, my lord. And in fact, my lord, I have collected, my lord, copy of the, my lord, that rule, my lord. Here, my lord, it is specifically stated, my lord, they shall come into force with effect from the date of their publication in the Gazette. My lord, till date, my lord, that rule has not yet been published, my lord, in Gazette, my lord. Now, my lord, on that basis, my lord, this regulation, my lord, the premise of the petitioners, my lord, briefly, my lord, had been killed, my lord.
Yes, respondents,
Notice may be issued, my lord, and whatever this publication is concerned, my lord, they have to answer whether it is published or not, my lord. I have to take instruction of that
yes, heard
particular
by the
rule
council
as
for the
he is
parties.
alleging. my lord.
It's returnable 3 weeks. MS M. Bormon appears for respondent 1, 2, 3. Sorry, 2 and 3.
Well-
Mr.
I appear only for
S. Borua for 4.
4.
Mr. A. Bhattacharya for respondent number
1.
1. The respondents will apprise the court as to whether the Assam Brick Kiln Establishment Regulation Rules 2013 has been published and has been made effective.
Yes,
Let this information be placed before the court by the next date. Since standing councils have entered appearances, notices are waived, however, extra copies be furnished within a period of 1 week from today.
problem.
My,
Notice on the interim grant
my lord,
to be considered on the next return
My-
date.
put a date, my lord. And the date, my lord, has the date for
21.
my. Obliged.
Lordship, let the matter be taken up for some time. Mr. Esbara is on late.
Time being,
My lord, limited pay in this petition. My lord, I have applied for my lord mutations long back. Lordship policy page 32. Only limited pay, my lord. The time frame to my lord page 32. Now this is the notice 27/3/2023, my lord. 1 year has elapsed, my lord. Nothing has been done. Again and again, notice are being issued. Lordship kindly give a limited time to my lord dispose of my mutation case to the respond number 2.
No, Lordship, I have to take instruction because notice to serve to the all the people.
No, notice has already been served. They know whatever Lordship. Let them take a call. In 2 or 3.
no, you want disposal of what?
My lord, page 32 is the notice. My lord, there is a mutation case pending since more than 1 year. Now they are doing nothing, my lord. This and that side, my lord, notice are being issued. Sometimes they are, my lord, taking the time, my lord. Lordship will fix a time so that the matter will be culminated, my
Get instructions, find out. Let us find out what has happened.
lord. Otherwise, Lordship, if you
instructions
dispose of
is-
them, Lordship, it will help. Lordship,
No, disposal, why?
my lord,
We must know exactly why, what is the
Yes,
delay,
Lordship, Lordship.
right? Let them get it. Heard Mr. S. Samari, learned counsel for the petitioner, Mr. N. Muslim.
One and two.
Love and advocate. Respondent 1 and 2, petitioner is aggrieved by the pendency, by the fact that the mutation case being case number 73 of 2023-24, pending before the Circle Officer, Guwahati Revenue Circle, Kamrup, District Kamrup Metro, has remained pending since it's when?
my 2005, 2023.
Since 2023. Stop. It is submitted by the council for the petitioner that the authorities have not endeavored to dispose of the matter for reasons best known. So, having, in spite of appearances before the authority, the matter has not been closed. Matter has not been decided finally. Stop being aggrieved. He is approached his court seeking an appropriate direction from the court. Let the government council obtain the instructions from the respondent 1 and 2 and place it before the court by the matter being listed on 19th April. In order to facilitate extra
Office.
the instructions, extra copies be furnished within a period of 1 week from today.
Deeply.
Main अपना है।
Yes.
May I please, Your Lordship? Your Lordship, the petitioner was serving in the Assam Police Administration Anam branch. His services were employed during the COVID pandemic. As a result of contracting COVID, Your Lordship, the petitioner's husband passed away in the year 2020, 7/7/2020. The medical report, Your Lordship, is at page 18. Thereafter, the state government, Your Lordship, came up with a notification dated 2/9/2020 that recommended 50 lakh ex-gratia assistance to the dependents and kins of those who were serving in the government departments who died combating COVID-19. But nothing was being done on that regard regarding the release of the ex-gratia payment, Your Lordship. The petitioner was constrained to approach his honorable court on an earlier occasion, with the writ petition being 1721 of 2022. That matter is still pending before this honorable court. While that matter was being heard, during the pendency of that matter, at page 43, Your Lordship would kindly see, which is the impugned OM.
Yes.
This OM had rescinded the earlier beneficial OM of 2/9/2020 that had sought about releasing an ex-gratia assistance of 50 lakh. This OM is under challenge in this entire petition. The ground for challenge, Your Lordship, is that under Section 12 of the Disaster Management Act,
This has been rescinded with effect from 13/7.
no, this is being yes, will come into force and immediate effect, and this OM was placed when the earlier matter is being heard as a ground for not granting the benefits to the petitioner's husband, petitioner on account of the petitioner's husband's death. Now, Your Lordship will kindly look into one record that we have bought, Your Lordship, which was part of the earlier writ petition. This was the status report. This was the status report, Your Lordship, which was furnished before this honorable court by the government. Your Lordship would kindly come to the second last paragraph. As such, after response from the Ministry of Home Affairs and obtaining approval of the Honorable Chief Minister Assam, this department would be taking necessary action for release of ex gratia grant of rupees 50 lakh as per government guideline. That has yet to come to fruition, Your Lordship. It is not in dispute that the petitioner's husband was involved in combating COVID. It is not in dispute that he died while combating COVID.
50 lakhs or 50,000
50 lakhs. 50 lakhs.
per head,
Per
per
head,
person.
per person. Because the 50 lakh, Your Lordship, is a generalized amount that is ought to take care of the entire dependents and kins of those we've lost during combating COVID. This notification gave right to certain rights of the petitioners. Now, if Your Lordship will issue notice, in the earlier matter, the National Disaster Management Authority was not made a party because these relevant instructions are not placed before this honorable court.
Yes, heard learned counsel for the parties. Yes, writ petition is filed with the petitioner in good challenge. The notification dated 13/7/2023, whereby the earlier beneficial notification of grant of ex gratia to persons who expired while
Combating COVID, Your Lordship.
while rendering service during service as government employees / as employees of the government, society, authorized PSU who died in harness due to COVID disease contracted while performing official duties in combating COVID-19 pandemic. Counsel for the petitioner submits that this notification was issued at a time when the petitioner's dead husband's application for grant of ex gratia under the notifications mentioned in the impugned notification, namely notification, the first one,
The first one, 2/9/2020, Your Honor.
2/9/2020.
Yes.
Notification number 29/2020, page number 43. the application was being considered. Stop. Because of non-release of the amount claimed, petitioner had already approached this court by filing WPC 1721 of 2022 and the matter is presently pending before the court. During the currency of the writ petition, the present impugned notification has been filed and therefore the writ petitioner has approached this court by direction of that. Para issue notice returnable. When is the next date fixed in the matter?
The matter has been not listed as of now.
Returnable 3 weeks. Mr. A. Bhattacharya appears for respondent 1
and
2. Mr. B. Gogoi for respondent number
3,
3. Mr.
Four,
N.
Lord.
Goswami for respondent 4. So you appear for 1, 2, 5 and 6.
I am appearing.
5 is the union.
5
5 is the union, Your Lordship.
MSK open and 6 authority. You appear for the authority of
Disaster management. No.
Mr. A. Bhattacharya appears for 1, 2 and 6. 6. All right. Mr. N. Goswami appears for
4 and 6.
6. 4 and 6. Since the councils have represented the respondents, notices of waive the extra copy will be furnished within a period of 1 week from today. That the this petition be listed along with WPC
1721.
17
21, Your Lordship, of
of
2022.
2020.
Wait, read it loud.
Hmm.
Actually, the petitioner is aggrieved by action of the respondent authorities in not demarcating the land settled with the father of the petitioner 24 years ago, despite clear directions of the Honorable Court as well as Government of Assam. Lordship, a parcel of land measuring 2 kathas covered by DAG number 1266 under Moja Mahabharava, Tezpur town was settled with the father of the petitioner. By communication dated 18/8/2000, it was informed by the Deputy Secretary to the Government of Assam. My lord will find the order of settlement at page 26 and 27. Lordship, in this communication, it was also directed that land records be corrected, patta be issued on realization of premium, and possession of the land be handed over to the petitioner. Thereafter, Lordship, another order dated 14/3/2001 was issued by the respondent number 4, that is the additional district commissioner, by which it was again directed that the land be settled upon realization of land value fixed at rupees 22,222 per kata. Lordship, the said premium was deposited by the father of the petitioner, and thereafter, my lord, another order dated
Council to the
11/4/2002 was issued.
Well, issue notice returnable for Mr. N. Goswami appears for all respondents,
Number 3, 4 and 5.
respondents 3, 4, 5. Mr.
I'm for 1 and
G. Azariga for respondent
1 and 2.
1 and
Lordship, during pendency of the petition, the possession of the petitioner may not be disturbed by law. Because it was already
Yes.
noted by the Honorable High Court also.
let the instructions be completed by the next week. Respect of the respondent. Prayer for entry will be considered after the next return of the
My pleasure, Lordship. My lord, the petitioner was allotted a railway plot plan to carry their business. So in the year on 6/6/2014, one notice was issued under Public Premises Act to vacate the premises
allotted by whom?
entered by the railway.
Where is that order?
That, my lord, on 6/6/2014, my lord, this order was, notice I am showing me page 25.
20?
a notice was issued under the Public Premises Act. That was carried before the, my lord, honorable, learned district judge of the Barpeta. And the appeal was dismissed. Then, my lord, they had approved before this honorable court, under Article 227, challenging the order of the learned district judge. That was adjudicated by this honorable court, and the judgment was passed. Thereafter, my lord, the petitioners, during the process, interim period, my lord, the petitioner was allotted another plot, which is at page 25. Sorry, 32.
Yes.
32. So they are carrying on this plot of business, the grocery shop,
So
and that page,
allotted by whom?
my lord.
Allotted by whom?
My lord, the SSC works, the railway, that the page 32 I am reading, shifting of the lease plot of the new location towards west side of the Borpeta Road. As per advice of the high official site, you are hereby advised to arrange of shifting of your plot, new location site, so and so, so and so, there, so and so. My lord, this order was, after this issuance of this letter, we are enjoining these premises. My lord, the proceedings in the earlier round of litigation with regard to the another premise under the PPA. My short question is that, my lord, without following the procedure of law under the Public Premises Act, they have issued now the impinged order at page 70, which is at removal of unauthorized structure from the railway line, page 70. This order was not challenged or not nothing on earlier round of litigation. Whereas they are referring with the right petition number so and so, which relates to the plot which was allotted eviction notice of 2014.
Where is the judgment of the?
Judgment, my lord. That judgment is at page, starts at page 52. Sorry, madam. Sorry. This judgment starts at page
55.
my lord. At page, my lord, this is a detailed judgment, my lord. That is at page, that is page 52. And that ends, my lord, in the last paragraph, my lord, I am dealing with page 68 is the direction. In view of the discussion, para 18, in view of the discussion made above and for the reasons assigned therein, the petitioners are found to devoid of any merit. The petitioners are therefore liable to be dismissed, and they are accordingly dismissed interim orders if any are recalled. In the course of the hearing, submission has been advanced on behalf of the petitioner that the respondent relatives have permitted some other persons to run their business in certain parts of the Borpeta Road railway premises. The state submissions have been categorically expect nor any materials have been sold. I am not going on this. Then, my lord, they were directed if the railway authority gives any arrangement, then they will apply. So, my lord, this writ petition is against the order of the learned district judge of this, my lord, at page 55 I am reading. All four writ petitions instituted under Article 220 of the Constitution of India have referred a letter dated 25/10/2015 written by the respondent whereby petitioner asked to arrange for shifting of their business of new locations indicated therein on or before 10/11/2015. The petitioners have instituted a writ petition seeking interrelated direction to the nature of members, direct the respondent to accept the license fee from which of the petitioners and to accept. As the subject matter of the four writ petitions similar and are letter dated 25/10/2015 of the respondent number 3 referred, they have taken up together and stage admission for final consideration at the request of the learned council parties who have submitted. In order to appreciate the contention we have the petition, it is appropriate that the WPC number in the year 1982 respondent railway authorities has provided that, my lord, the license to the one late Chandi Prasad Mahajan, who was the uncle of the petitioner, took away railway plot of land, plot number 26. Plot number 26 related to that eviction notice issued by in the year 2014. Then, my lord, the square of where Borpeta railway station or the temporarily, according to petitioner state license, then, my lord, I am not skipping. The petitioner has claimed that since the initial license agreement arrangement of the and after that, the petitioner had been continuous occupation of the license railway plot number 26 within the Borpeta railway station premise. It was therefore 2013, the petitioner was served with a notice of cancellation of 2025/10/2013. Whereby he was asked to vacate the license railway plot number 26. By the notice, the petitioner informed that the license railway plot number 26 is required to be development, circulatory, Borpeta, and as such, he was required to vacate the same removing all the material structure within a period of 30 days, receipt of the notice of 25/10/2013. Then, my lord, this was there. The other repetitions facts are there. This is a common, it is para 4 of page 57. It is the common case of all the petitioners that when respective license relay plot of the land given to the temporary occupation, the same was the low-lying ones, and the petitioners had filled up the same with art and spending money with their ends. The plots of the position was therefore the notice of the cancellation dated 25/10/2013 was followed a notice dated 6/6/2014 from State Officer NF Railway, Rongia, Form A, issued exercise of powers under section 4 of the Eviction Act 1971. Then by the said notice dated 6/6/2014, the state officers called upon the notices to suppose to appear before him on 36/2004 office of the DRM railway hearing. The notices were also asked to bring all the evidence in support of the shown and this one hearing.
The
Personally,
judgment appears to have dealt with this issue.
no, that all the issue, my lord, that was with related to that judgment of the Lana district judge related to.
No, no.
But there is, my lord, the procedure was not followed with regard to this, my lord, these premises which we are enjoying.
Yes.
Where lossy issues a 10th penalty is litigation barred by principle of re-adjudication, which was already decided also.
This
And-
matter also, there is a reference that you
And
did, whether the authority had the authority,
Well,
correct authority to.
That
issue.
reference was there,
and this
but this notice was not, my lord, this
Notice
another
was-
letter, that was not
Obviously,
there.
this notice was not there, but the
Right.
issue has been settled. Court held that.
That, my lord, my humble submission before your lordship is there.
Hmm,
I'm coming to page 65, para
Yes,
15.
yes.
It has been held by the Honorable Supreme Court, so I'm keeping up this citation, the exercise also, that the appellate officer exercising the power under section 9 of the Public Premises Act does not act persons designator, but in this capacity of the pre-existing judicial authority in the district, being district judge or judicial officer presiding essential district judge. Being apart from the district judge, the judge acts as a court, and under the passed by this order subordinate court, which under the Article 227 of the Constitution of India can be built on the method related exercise of such jurisdiction. It has been concluded that the order passed by the district judge as an appellate officer on section 9 public information under the
Have you
subordinate
filed an
court.
appeal against this order,
My lord,
against the judgment?
that is, we are, before this, after we again approach this honorable court by another writ petition. After this, during that period, my lord, they have issued this letter.
You kindly come to this page 66, para 16.
Para 60. The only other aspect of this following of the consideration is whether any new license arrangement has been created because of the letter dated 25/10/2015 issued by the respondent number 3. By the letter dated 25/2015, the petitioner advised to arrange for shifting from their earlier license plot of the land new location indicated therein by the completing the shifting work within 10/11/2015. It has been
Now
contained,
come to page 67,
my lord,
towards uh,
my lord.
10 lines from the bottom.
Yes, the petitioners have not brought anything to dislodge the contract of the railway authority that the respondent had no power, authority, and jurisdiction. In the absence of any approval, permission, competent authority to allot any plot of railway grant license.
So there is a finding that it has
Yes,
not
the
created
letter
any
dated by the
license.
consequence, there is a finding that was their submission, this is not, but not by a competent authority.
That is accepted by the court.
Court.
There is a finding that it does
And
not
the
create a
competent authority to
license.
the alternative new locations have created any license arrangement between the petitioner and respondent. The statute that is, the Public Premises Act.
So your grievance today
My lord,
is that in view of this letter at page 32,
my lord.
you have been shifted to a new place and you are continuing your business there.
My lord, no, during the, after this judgment, we shifted there, another, which was related in the 2015.
Where is that letter?
My lord, that 15, my lord, that is page 32, 25/10/2015.
That's right.
Which has
So,
been dealt here.
so it is, this letter has been referred here.
Yes, letter, that I'm coming, my lord, next line.
Hmm.
Next line, the statute that is the public premises empower the competent authority to act public interest. As owners of the plot of land, the competent of the respondent is entitled to deal with the railway land public premises in a greater public interest.
Hmm.
Respondent related have asserted there is a urgent imperative under the efficient development of the Borpeta Road railway station premises and construction of the so-and-so restoration area. This as has been found at the railway board with the master of so-and-so, they has already stopped the policy of the temporary licensing, the area so-and-so, handscaping. That has been dealt, my lord. I'm not, that has been dealt. Paper. My lord, my contention is that we came against the order of the learned district judge under the, after the issuance of the notice under the Public Premises Act 2014. So that has been considered. But we have, since we have shifted in a new plot by virtue of that letter of
That
2015,
letter has been held to be not authorized.
that has been, my lord, that has been, there is no finding that was whether that was carried in the by the
There is a finding, there is a categorical finding.
under the act, my lord, whether procedures are followed or not.
No, no. That process will have to be followed, provided you have some authority to show
My lord,
that you were in that place
my lord,
by a lawful authority,
my lord,
under lawful authority.
my lord.
Your ground is this letter at page 32. This has been held that it is without any authority.
My lord,
That finding remains.
findings remains, my lord, but with regard to that premise, my lord, with regard to that premise, that is 2015,
No. This
no procedure was followed.
25, 10, 15 is with regard to the premises that you're.
Lordship,
That-
paragraph 17, Lordship, in the next writ petition is page 68. 1, 2, 3, 4, 5, 6, 7th line on bottom, Lordship. May I read, Lordship? It cannot be accepted that the letter dated 25/10/2005 and the
No,
consequent
you are reading from
paragraph 17,
It's in
Lordship.
page 67, Lordship. That
67,
restriction,
yes.
Page 67. Lordship.
67.
Page 67.
it cannot be accepted.
Lordship.
It cannot be accepted that the letter dated 25/10/2005 and the
That's the finding
consequent
there.
clues to the alternate new relocation have created any license arrangement between the petitioner and the
That's the
respondent
finding
railway
against
authority.
you.
The clear finding, Lordship.
That-
Then final.
My here, my lord, another prayer is that, my lord, we have my lord, some expenditure made. So that expenditure,
Certified money suit, Lordship.
that expenditure, my lord, that is another prayer, my lord.
Yeah, expenditure on what basis? Who has?
At his own
on-
risk,
On
Lordship.
the premises that we are
You
elected.
are unauthorized persons.
Mhm.
Whatever expenses you have incurred on your own.
My lord, no,
Why should the railway
my-
be settled?
my humble submission is that the plot was allotted by the railway where we have constructed.
No. That has been held to be unauthorized. That letter was not held to be a letter issued by a person with authority.
That's my lord,
That finding is there. You have not appealed against that.
my lord, this is not that. My lord, this, my submission is that, my lord, since my lord 2000, that notice earlier premise, which was we allotted, there we have a my lord incurred expenditure.
Who has quantified that? Who will quantify? What
Well,
expenses?
Let the railway authority,
Why should they do it? You are unauthorized.
my
You are
lord,
unauthorized.
that compensation. My another contention is that at page, my lord, 29, para 29, some other persons, para 29, my lord. I have given the specific names of the some other persons. That the para 29 of page 19, that the petitioner basically, like the petitioner, the railway authorities also allotted land on lease some other persons to the business. The railway authorities have made alternate arrangement of land to similar divisions to run their business. So let them at least take instruction on that, whether, my lord, para 29. We can be,
Yes.
See, there cannot be a, Lordship, any alternative arrangement as because yesterday also my Lord said there will be one matter also regarding Amrit Lordship development project of the railway station. Lordship. All the railway station all over India. Lordship.
His grievance is that some people have
Lordship,
been given some benefit.
that also not there. Lordship. Nowadays, Lordship, it should be all the railway stations should be dedicated for development purpose. Lordship. It is there, Lordship, a central government project. And this case also, Lordship, attained finality, Lordship.
You get the instructions with regard to para 29.
29, Lordship, at this stage, as because, Lordship, the project is going on, Lordship, there cannot be any alternative arrangement also. Lordship.
But there is a statement made, unless you have the instructions whether it is correct or incorrect. You have
That
to
part we can take instruction,
You take
otherwise,
instruction.
Lordship, the issue is attained finality, Lordship, is not prefer an appeal against the order of the Honorable Single Judge, Lordship. And Single Judge categorical finding is there, and on the basis of that, Lordship, that particular notice was issued, Lordship.
All right. Yes, Mr. Chakraborty, anything? You are also appearing for railway.
In the next item, in the next
Next.
item.
Heard learned counsel for the parties. Petitioner is before this court to challenge the order notice dated 19/8/2023 issued by the railway authorities, Northeast Frontier Railway authorities, directing the petitioner to vacate the railway land under their unauthorized possession at Borpara Road Railway Station. Stop, comma, failing which they will be evicted from the said area. Where the petitioners claim to be carrying on small businesses in the Borpeta railway station by running. What is your business?
Grocery shop.
By running a grocery shop. Grievance of the petitioner is that earlier they were running the grocery shop at a plot of land. However, subsequently, by communication dated 25/10/2015, issued by the SSE / works / IC / PRD NF Railway. They were shifted to another plot of land, measuring 5 meter into 5 meter. Stop. Since pursuant to the letter, the petitioner shifted to the next plot of land and has been carrying on his business from the said plot of land. So it is from this plot of land that by way of the impugned notice, the petitioner is sought to be evicted. So petitioner is aggrieved that the procedure prescribed under eviction of unauthorized occupants from public premises eviction of unauthorized occupants Act 1971.
My lord,
71 has not been followed. Stop. In respect of the earlier,
Okay.
yes, earlier provision, in respect of the earlier, in respect of the claim with regard to the earlier plot of land where the petitioner was carrying on his business, he had approached his court by filing WPC number
214 of 2008.
214 of 2018. So this writ petition, along with other writ petition, and this writ petition came to be dismissed by judgment and order dated 8/8/2023, whereby the court did not find merit in their writ petition. So, parallel counsel for the petitioner submits that in the earlier writ petition, the impugned notice was not challenged, and consequently there was no finding by the court. Therefore, is before the court praying for adequate orders. Para. Mr. K. Gugoi, learned CTC appearing for the railways, strongly objects to the contentions made by the petitioners. He submits that by the earlier writ petition, their judgment and order dated so and so, the writ petitions were dismissed, and in the order, a reference to this letter of 25/10/2005, 2015, which was issued to the writ petitioner for shifting his place to the present place which is under his occupation, was also referred to, and there is a finding by the court that his letter is issued by an officer who is not authorized to do so. He therefore submits that the matter has already been decided by the court by the judgment and order dated so and so, passed in the so and so, and therefore this writ petition stands barred by res judicata, by the doctrine of res judicata. Therefore, we dismiss as not maintainable. Whereas the writ petitioner, rejoinder, further submits that at para 29 of the writ petition, he has given reference to, he has named certain persons who are similarly situated and whose cases have been considered by the railway authorities, and they have been shifted to alternative places within on the railway land and are still carrying on their livelihood. Having heard learned counsel for the parties only on the limited question of whether the statements made in para 29 of the petition are correct or not, the learned counsel for the railways is permitted to obtain the required instructions in the matter. Let the matter be listed again.
Next week, Lordship.
14 June. So at this stage, no notice is issued. However, in order to facilitate the learned counsel to obtain instructions, that extra copies be continued within a period of 1 week from today. List again on 14.
May I
Particular
pre-
orders in the next matter, standing counsel would be.
my lord, may I prefer the interim protection till
What interim?
eternity.
That part was.
My lord.
Oblige.
We are leaving it open.
Oblige.
If you insist, we'll reject it.
My lord.
Oblige.
Yeah, yeah. But in this case, Lordship, petitioner, Lordship, for setting up a water mineral, small industry, Lordship. Apply for a Lordship financial assistance under Prime Minister's Employment Generation Program. Thereafter, Lordship, his loan was granted, Lordship, by the Punjab National Bank, Lordship, and the demo and page 55, Lordship, and page. And the loan was sanctioned on two heads, Lordship, the capital expenditure and working capital. Lordship. Capital expenditure was Lordship released, and he was started some Lordship machineries and started the industry, Lordship. Subsequently, Lordship, one working capital was released, Lordship. An amount of 1,28,000 Lordship was converted by the Lordship, the then Lordship manager.
Yes, any instructions do you have?
We will take it. Notice may be issued. We will take.
Notice it. Okay, heard learned counsel for the
Amen.
parties. Returnable 3 weeks. Mr.
A. Dhanuka.
Appears for the respondent.
120. 120.
1, 2, and 3. 1, 2, and 3. Where is the industries? Yes, Mr. Kolita. N. Kolita. Industry. DIC.
Yeah.
Respondent number 4. Mr. A. Kolita appears for respondent number 4. Steps on respondent 5 and 6. As well as equal courts within a period of 1 week from today. Matter be listed after the returnable date. Since the councils have represented respondents 1, 2, 3, and 4, notices are waived. However, extra copies be furnished within a period of 1 week. Yes, Mr. Mohan.
I'm grateful for the accommodation.
Perhaps from next week, you will not be discomforted with regard to the timings.
Well, that is always needed, my lord, otherwise. Well, what happened?
Yes.
This order, which is punitive in nature, not in nature, is a punitive order issued against this petitioner, cooperative society, on a charge which could not be substantiated wrong. There is no evidence of it. Some allegations are made. My duty is to transport the food grains from the FCI to the GPSS go down in the first tier. Then in the second tier, I have to distribute it to the shops, fair price shops, on the allotment made by the society. Everything was done, but there was no allotment made to me subsequently for the distribution. This was by the GPS.
In the inquiry, they have said that it is the officials of the GPSs. They have done it. They have done it. So, can you see the impure order? It is believed to be diverted. Such a harsh punishment on me without any evidence. At page 76, Lordship will kindly see. This is the order dated 26 June 2023. I am a transporter cooperative society. From the bottom, fourth paragraph, Lordship will see. Whereas it starts with whereas Messrs. Number of GPSs has not distributed. This is number of, that is GPSs, has not distributed TPDS rights to the FPS dealers for honor distribution to the beneficiaries within the government stipulated time frame, that is this time, and June 23 quota till 15/5/23. A part of May 23 quota and the whole allotted quantity for June 23 quota is believed to be diverted into open market by the transporter, is believed to be diverted. This is what only finding is believed to be diverted into the open market by the transporter Mrs. So-and-so, Larva GPSs Limited, in league with the office bearers of Mrs. Namru GPSs to garner undue illegal profit. On this belief, my lord, only on this belief, what they have ultimately said, authority has, next page, Lordship will find, security deposit of 10 lakhs has been forfeited and license has been cancelled. For that, there must be some specific, very definite evidence. There is nothing. No inquiry was made. Suppose I have replied that, look, these are the documents. You see, all delivery was made. They have received it. This was there. So, apparently, the order cannot sustain this scrutiny of law. Let the authority respond to it, Malak.
All right.
Let a notice go in the meanwhile.
Heard Mr. K.K. Bhansal saying Mr. P.J. Talukdar.
All the.
Petitioner is aggrieved by the impugned order dated 26th of June 2023, whereby the petitioner was settled, petitioner's security deposit of 10 lakhs have been forfeited, and the license
Transportation contract has been
the
That-
agreement with the NFAC transport agreement with the transporter petitioner has been terminated by the same order. Learned Senior Counsel submits that the only ground for cancellation of the debtor agreement, transport agreement, and forfeiture of the security deposit is on suspicion that the petitioner had diverted into the open market the allotted quantity for June 2023 in league with office bearers of MS number of GPSs for illegal profit. So, Learned Senior Counsel submits that there is no specific finding pursuant to any inquiry conducted. Stop, no notice was given to the prior to cancellation by way of the impugned order. Accordingly, this impugned order is contrary to the basic principles of natural justice, and therefore they interfered with the set aside in court. Issue notice 4 weeks since Mr. Talukdar represents the respondent, which is a waived extra copy to be furnished within a period of 1 week from today. Matter be listed after returnable date?
Sure.
After
Return-
4 weeks?
Okay. Meanwhile, my lord, notice on the stay prayer also.
Notice on the stay prayer to be considered, the same return date. And let's get it on. That we have it after the reopening day,
One, no?
Yes, July.
17th July.
Yes.
Yes.
Matter be listed on 17th July.
Apply.
Yes.
May I please, your lordship. Lordship, this is the same case, lordship. Time barred lordship assessment. The order is at lordship page 112. The similar order, lordship, which the lordship has already passed. Okay, there are two issues in this case. One is time barred, second is section 16(4). Lordship, at present, lordship, for the purpose of lordship interim, I'm only pressing this court. Otherwise, I would like to argue on 2 points. Finally, when the matter comes.
Let us issue notice first.
Yes, your lordship.
Who represents the authority?
I'm representing 1 and 2, your lordship. GST.
GST authority. Third MS in Haveli and Mr. Dr. Gogoi hearing for respondent. 1, 2, 3, 4.
Only 1, 2, your lordship. 3, 4 is the stadium.
1, 2. Mr. P. Gogoi appears for respondents 3 and 4. Issue notice returnable 4 weeks. To be listed along with WPC 2722 of 2024. When is this matter listed?
Lordship, there's no fixed date, 4 weeks.
It's on 17th July. We'll have it before vacation. Have it before vacation. It's on 19th June. 19th June, along with WPC 2722 of 2024, is the next returnable date. No recovery.
Lordship, the interim is still further order in this case. Lordship has passed the order until further orders the interim.
We are giving it in this matter till 17th June. We are directing this matter to be listed again. 19th. All right. Extra copies we furnished to the standing council.
Much obliged.
For admission, I think 21.
Well, these were the matters which you also may remember, Miller, that where Miller, the extension for eligibility amendment was made and it was provided, Miller, that those applications which are pending shall be deemed to be rejected, Miller.
Some affidavit was to be filed.
Miller, the affidavit has been filed in 2 cases. In one case, they have not filed the affidavit. In other cases, Miller, we have withdrawn it because with liberty to file fresh one.
Right.
Because those applications were rejected. Here you will also find the application affidavit. The list of names which has been given, in this the petitioner's name is not appearing. In fact, I completed the argument, they only want to file affidavit.
Well, Mr. P2D looking after this case, madam. Today is not present. Madam. Can be put it up after party.
That is available. Can have it on 4th. 4th? Submitted that.
Of course, there is one matter affected at what in the morning itself. If it is little accommodation, Miller, so
In that case, madam, on 8 or 6 is it?
no, 4th itself will either will do it to 2 o'clock or 6.
On 6 in that case.
Huh?
6.
It will be on 4th if it is not possible.
Yes,
we
yes.
refer it.
We'll over to
Otherwise, this matter had already proceeded in the hearing.
not
At the request of the request made on behalf of Mr. P. Chaudhary, listed again on 4th of June. Dr. Ikara, assisted by Bora.
PK Bora.
Bora. List on both of you.
I think 30.
My lord, here in this case, my lord, after having a long battle, legal, my lord, battle, we won the property. Now the opponent still playing proxy war, my lord. And my lord issued a notice that is in page 29, my lord. Page 29. Now, lord, see the two questions are there. First thing, assistant town planner deserves no authority to issue such kind of notice. Downside, my lord. Second thing, my lord, under which provision of law this notice was issued, nowhere mentioned, my lord. And so far, my lord, letter has been received from Samir Chaudhary, my lord. That is the, my lord, person who has been employed by my opponent, my lord, to just disturb my lord, part of construction. Lordship, just see for a moment. Paragraph 8, page 8, my lord. The power given to the commissioner only, my lord. The commissioner is only the competent authority to issue such notice, my lord. Section 34, and thereafter, my lord, section 37. And lordship, just take a turn to next page 9, downside. There are certain, my lord, exception case where the power cannot be delivered to other side, my lord, including section 337. That is related to the building matter, my lord. My lord, suppose if assistant town planner who is not an authority at all, my lord, how he can issue notice, my lord? But only one citation I would like to place that without jurisdictions and authority, my lord. Lordship has already decided. My lord, thing is that, my lord, even it is not a town planner, assistant town planner deserve no authority, my lord.
All right.
This letter is only sitting for a document to verify. Thereafter, the 37 and everything, if that is.
No, but whether he is, according to him, he is
Yes,
not
yes.
even authorized to issue
No,
that.
Lordship will turn to the, Lordship will take the book of DMC Act, section 37. Only in certain provision of the law, DMC Commissioner have to do it. Page number 26, section 37. Down below, section 37.
Delegation of
Commissioner's ordinary power. These are the sections of which the commissioner cannot delegate. Others we can others we can delegate. Here only the project planner is taking
so
some
this
document.
this notice is under what?
No, notice there is this notice only to verify the documents. If the documents is found to be they give NOC and everything, no further action will be taken.
No, but on what basis? You have to enclose a
Notice there is no section, madam. There is
no. Why have you issued a notice to verify the documents?
because the complaint has come.
That's right. So have you enclosed a copy of the complaint?
No, that has been stated in one Samir's tutorial when a complaint.
So you have to give a copy of the complaint. Somebody has lodged a complaint doesn't mean you call for the record.
It's not only
Lordship, may I point out only one thing, my lord. This section 37 clearly says one thing, my lord. 37, Lordship. Kindly look for a moment. The commissioner may delegate to the holder of any municipal office any of the ordinary power, duties or functions except those conferred or imposed upon or vested in him by following provision, including 337. Now, Lordship, take it for a moment that this is a matter pertinent to building matter, my lord. 337, my lord, clearly says the power only enjoyed by the commissioner.
Yes. 337 will come later on. If the notice comes, the commissioner will.
It's a beginning point, my lord. Source is itself is without jurisdiction.
Commissioner will not write a letter for getting
Absolutely,
the NOC.
It's a serious consequences we have to face, my lord. There's a clear line, my lord, commissioner, my lord.
But before you ask, somebody has to take a decision that on the basis of this complaint, you'll have to issue a notice. Ask him to appear before the authority before you ask for document.
It may not go at that in. The first the document they provide, if there is a NOC, nobody will give the notice under 337. That may not be progress. The complaint may be a frivolous one, just to inquire that all the documents he have it. Ultimately, it will not proceed to the 337. Commissioner will not give a notice to get all these documents. If the 337 is proceed, commissioner will have to do. That's why there is some.
Assistant commissioner, how, my lord? Is a-
Assistant
my lord,
town planner.
he's even not a town planner, my lord. Assistant town planner, he's a.
Only seeking the documents. If the documents are
Why
correct.
will you seek a document just like that?
Well,
Just because somebody
ultimately
comes and
later the complaint will.
somebody comes and files an application, you will straightway ask for documents. Will you not register some kind of a proceeding?
Inquiry or what?
Because the documents is that particular house or what a building, document is within the possession of the person who is
That's
holding.
right, but you'll have to discuss, you'll have to decide on what proceedings you have.
Under which provision of law?
It is the beginning, my lord. It is the beginning. The documents he furnishes it. Ultimately, we are satisfied.
Are
Will
you
not
telling
proceed.
me that anybody can walk into the GMC's office and file a
This is
complaint,
happening, my lord.
and then the notices will go, citizens will come running to GMC's office carrying.
Then bargaining, my lord. Then.
That ultimately that some neighbors or anybody have to give a complaint. Otherwise, we
That's
cannot
right.
check.
So whether that complaint is justified, not justified, somebody has to.
That's the
There has to be.
yes,
proceeding
that's the beginning. The justified, whether not justified. The moment the documents come from the person,
provided there is a procedure followed. Where is that procedure? You have to register some kind of a proceeding.
it
That
may not.
somebody has filed a complaint.
It may not go to that particular point, my lord. The moment the document comes, NOC comes, we settle it. This is a frivolous complaint, my lord.
Tomorrow, supposing you decide that there is a defect or NOC is not there, what will you do?
Then the 337 notice commissioner will.
Yes.
Then
337 notice.
Then what is the basis of the 337 notice? On the basis of some complaint lodged by somebody.
Well, that is with 337 and 2 is a so-called notice.
What does 337
one so-called notice?
Kindly see,
This is a so-called notice. Then you have to give a reply. 337 is a 1 and 2 will be a so-called notice. Thereafter, the final notice will come.
My lord, ab initio source is, my lord, not tenable. And thing is that, my lord, let them show that under which provision of law this assistant town planner deserve power, my lord. That's all, my lord. Nothing, my lord, required. If he deserve power, that notice is tenable.
This is the exclusive power of the commissioner, 337. We will give a 337.
That is the beginning point, my lord. This is the notice to be issued actually by the commissioner asking any document, my lord. No one else can issue, my lord, such kind of notice. Line is very much clear, my lord. Pass the plan, my lord. Purely bypassing power, my lord. For vested purposes, my lord. Since they lost the battle, legal battle, my lord, now they are taking this turn, my lord. And now that authority is now helping them, my lord.
It will require some examination because
337 and 2 is a so-called notice. It will come later on. Even it might not come to the 337 and 2 notice. If you give the document, verifying it, found to be everything is okay.
But let them show the authority, man. Simple saying that anybody cannot issue.
no, but you see the letter. You are requested to send a copy of DMC taxes,
Yes.
no objection, approved plan, occupancy.
Yes.
He is asking for the whole lot of documents.
Yes, well,
I can understand that he is asking for one particular set of documents. He is asking for everything.
Yes, first of all, the NOCs have to be there. If
Then-
something is going on, the assessment has to be there. All these documents have to be there.
So why is he asking for documents? Why is he not ask the person to come and visit in response to a complaint? Here the person.
Ultimately, it has to be supported by a document.
That's right. He'll carry the documents, but you put him to notice, ask him to appear before the authority.
No, well, what is there is allegation. Hence, you are requested to submit the copy up to the tax date so and so.
This practice is
You are a public servant. You cannot just assume power and decide to do it unless it is well
Vested
defined
under
under the
law.
procedure.
Hello?
Who has given you the power to issue a notice? On what provision?
Before issuing a notice, before this is just a letter to get all the documents.
Who has authorized him, whether it is in his domain to issue a notice like this?
That is the thing, man.
Ultimately, the 337 1 and 2 have to be there. But
Different issue,
before you
sir.
get the
You get your instruction. This kind of, you can't just issue a letter like that, asking all sorts of documents to be placed before the
before
authority.
placing the
whether, let us say he comes and places all these documents, whether this authority is
Competent.
qualified and competent to examine these documents
law.
and give a finding.
He will examine the.
How he can
document and
decide,
he-
my lord, if
he
this
can-
is
he
not
will examine
empowered?
whether all the documents are there. If the documents are not there, only then the commissioner will act.
No.
Otherwise, not. my lord.
You show us from the procedure how it is there.
My lord.
Heard Mr. S. Tamaria, learned counsel for the petition. Mr. S. Bora, learned standing counsel for GMC. Petitioner is aggrieved by the impugned notice stated 10/5/2024 issued to the writ petitioner, asking the petitioner to submit copies of up-to-date GMC tax receipts, no objection certificate, approved plan, occupancy certificate, and NGO's receipt for conservancy service of the construction undertaken by the petitioner. Stop. This, it is mentioned in the notice that this these documents are sought for on the basis of a letter received from one Samir Chaudhary, making allegation of illegal construction by the writ petitioner. Stop. Mr. S. Bora, standing counsel, submits that there is no defect in issuance of a letter to examine the documents. If the documents are in order, further proceedings will not be proceeded with in respect of the writ petitioner. At this stage, it is only a question of examining whether the documents in respect of the writ petitioner are in order. So, let notice issue returnable 3 weeks. Mr. Bora will apprise the court the provisions under which the assistant town planner EMC is competent to issue the impugned notice dated 13/5/2024 and to seek for the documents mentioned. So, Mr. Bora will also apprise the court procedure prescribed under the GMC Act /rules/bylaws or any notification as to how complaints are submitted by individuals or groups of citizens in respect of illegal instructions are required to be proceeded or acted upon. So, let these instructions be placed before the court by the next date. Notice on the interim prayer also. Till the next date fixed, the impugned notice will remain state. Let's this matter again on 21st June.
Because
Since
there is
Mr.
time limit.
Bora appears, extra copies of the writ petition be furnished within a period of 1 week to enable him to obtain the required instruction.
Only thing is that my time is running, my lord. Lordship, please to stay the, my lord, please notice.
You stated.
Item 24.
May please, your lordship. Filed order dated 16/5/2024, lordship. I was directed to file wakalatnama in this case. So the earlier set of counsel, lordship, they cannot appear, lordship. So we tried, Mr. Tegogo was there, now he can't appear. We tried to contact the lordship client, but we could not contact. We could not get touch with him, lordship. So lordship, if lordship permits, I may proceed with the case, or lordship, for which time may be granted, we'll try again, if sufficient.
What is the grievance here?
Grievance is that he applied for the petitioner applied for DIC loan of 5 lakhs rupees. And thereafter the loan was sanctioned, amount was 2,85,000 rupees. Out of the 2,85,000 rupees, initially 41,000 rupees was released by the Union Bank of India. Thereafter, lordship, an amount of 1,11,000 has been released directly to the lordship, the hardware store lordship who provided the lordship instruments or lordship the machines for setting up a rice mill, rice selling mill. Lordship may come to face the sanction of 1,11,000.
Now, what is his grievance?
His grievance is that lordship,
I think all the amount, only 1 lakh out of 2 lakhs 85,000, only 1 lakhs 52,000 has been released. That is 1 lakhs 11,000 directly to the company, and the company has provided the machines. 41,000 was provided to him. He has constructed the shed. Lordship, that was inspected and that was verified. Thereafter, 1,11,000 was directly issued, released to the Lordship, the company for releasing the Lordship, the machine, to issuing the machine. Thereafter, Lordship, the for non-releasing of the remaining amount, he could not even, Lordship, make the electrification of the unit also, Lordship. So he could not run the unit. So now thereafter, petitioner, the authorities in the bank have issued a notice for recovering the amount that was paid to him. He has already, Lordship, requested to the newspaper also that you come and visit, inspect my unit. It's non-functional because of non-releasing of the
The loan is provided through the bank by the DIC.
DIC. It was sanctioned.
No, it was not by the DIC. It was by the bank to the person.
Ba-
DIC is only involved with like processing the application form. It doesn't have any other role. It is the bank who has
Bank,
stopped
yes,
it.
sir.
So bank counsel
Yeah.
is required.
Bank counsel, bank has stopped it, and because of
Who is the counsel for the bank?
Union Bank of India.
Union Bank of India. So number 3. Lordship, for these years, we could not run also it is in the defunct state also, Lordship. We have repeatedly requested the authorities come and inspect. He is from below poverty line family person, Lordship. How can he, Lordship, pay the amounts? Even thereafter also, he has paid some installments also, Lordship, and near about 11,000-12,000. He has already paid also. But the bank authorities have issued the notice and started the certificate proceeding, which has been stopped by the order dated 4/2/2016. It was stayed. And the amount was not directly released to the petitioner. Page 27 is just a Lordship. It was issued to the BB hardware store, one hardware store. Page 27.
No, but where is the counsel for the bank? Some affidavit has also been filed
Additional affidavit bringing the Lordship the certificate profit.
by the bank.
Bank Lordship.
Do you have a copy?
Bank affidavit Lordship not in the file. You will have to wait it much.
It has been declared as an NPA.
Not true.
You have received a copy.
Right now, I don't have, must have received. Okay, without receiving, how can it be filed?
Mr. Govinda Learned Counsel appears for the. He submits that he has been recently engaged in the matter. He requires some time to reconstruct the brief and complete his instructions from the petitioner. Mr. Kolita appears for the
1 and 2 lots.
respondent 1 and 2. Although the bank is represented by a counsel. Bank respondent 3, Union Bank is represented by a counsel. But today when the matter is called, the current counsel is not representing the bank. Mr. H. Sharma for respondent number 4, Deputy Commissioner. The matter be listed after 2 weeks.
Obliged.
May I please your lordship, lordship, in this matter, I was required to file my affidavit on behalf of respondents 1 to 4. Lordship, I've been informed, lordship, that it has been sent for waiting to the archaeological survey of India. He does not come back. Therefore, lordship, I am seeking some time.
Mr. R.K. Chaudhary, CPA, PSDI, submits that further time is necessary for filing the affidavit. Mr. Chaudhary, Hazarika. Hazarika, counsel appears for the it's again before.
Lordship,
After 2 weeks, 3 weeks.
let it be after 3 weeks. not okay. So-
Interim order, pass resolution. What is this heading?
Lordship,
What heading?
lordship, they make it from here, then that has to be again approved by the central officer.
It's the DSGI who decides what goes in the affidavit.
It's still not in my hands.
Item 26, lordship. Mr. P. Sharma is appearing for the petitioner. He was here, lordship, and
He is not here now.
no, now he is on legs, lordship. So he requested me to for an accommodation next week, any day as per his lordship.
None appears for the petitioner.
But I'm praying for a date, lordship. Can be
Let
disposed
the
of.
matter be listed next week. Mr. H. Sharma appears for the petitioner. Matter be listed on
7th, lordship.
7th of June.
Lordship.
MSD Hazarika for respondent. One.
Made please, your lordship.
Yes.
My lord, here in this case, my lord, I am challenging the order of my lord, page 21. That is the impugn order, and that was passed, my lord. I'm challenging on the ground that is a without jurisdiction and without issuing any notice. And in a case of demarcation, my mutation has been cancelled, my lord, which is completely, my lord, separate jurisdiction, my lord. Your lordship kindly see that order at page 21, that the impugn order, my lord. That was a case for demarcation. But in that demarcation case, my lord, it's absolutely without jurisdiction, my lord. And that point, my lord, no answer has been given by that has not been denied by the respondent, my lord. First of all, my lord, respondent, by every respondent, not filing any affidavit in this case, my lord, not denying this, my lord. And government also not denying that.
Yes, then.
So your lordship kindly see that order, my lord, page 21.
Yeah.
Page 21. Examine the case records. There is a, my lord. First of all, your lordship kindly see the heading, my lord. Certified copy of the order dated in the respect of circular dispute revenue circle in demarcation case. This is a demarcation case. Examine the case records in the report.
Demarcation of what? Boundary.
Boundary, my lord. So in that case, my lord, my mutation, which was granted in way back in 1967, my lord, that has been cancelled. And that too, in that respect, there is no notice issued to me. And even that is not their pair, my lord.
Then have you approached the next higher authority?
No, my lord. I approached this honorable court immediately because it's a without jurisdiction, there's a principle of natural justice. That's why immediately I approached this honorable court. And your lordship kindly see the, my lord, the order, various order passed by this honorable court.
Your lordship kindly see the order dated, my lord. Because they have already, my lord, record correction on the basis of that illegal order, my lord. Your lordship kindly see the order dated, my lord. And 8/11/23 of this honorable court, my lord. Eight 11, my lord, by this honorable court.
Yes.
Pursuant to the order passed by this court on 17/10/2023, the circle officer dispute Revenue Circle Kamrup Metro has filed his affidavit in opposition, and this court will deal with the said affidavit in opposition at a later stage and find it relevant to take note of the brief history of this lead to the finding this case. The petitioner herein had purchased a plot of land measuring 8 bighas 2 katha to 10 lesa by registered deed sale deed registered deed number of 6199 dated 22/9/1966 from the predecessor in interest of respondent number 4. The said land was recovered with DAG number so and so. The petitioner is aggrieved in the instant proceeding on the basis that the demarcation proceeding is initiated in the behest of the respondent number 4. The demarcation case number 225 of the name of the petitioner in respect of the plot of land measuring 19.30 area which is respondent 1 bigha 2 katha 4 lesser covered by DAG number 28110, including the KP pattern number 198 was struck off and the name of the respondent number 4 was inserted. The court by the order dated 17/10/2003 has directed the circle officer dispute Revenue Circle to file affidavit before this court. On perusal of the affidavit, said affidavit by the circle officer dispute Revenue Circle revealed that the mutation of the petitioner was cancelled on account of the fact that the petitioner land was already mutated by the order dated 6/2/2070 in mutation case big number PS case number KP pattern number so and so on the basis of the said deed sale deed number 1966 in respect of the plot of land measuring 8 bighas 2 katha 10 lesa. However, the perusal of the said affidavit revealed that the old DAG number 392 which contained the measuring of 8 bighas 2 katha 10 lesa became DAG number 559 and thereafter became DAG number 607 and subsequently DAG number 2813. However, the area of DAG number 2183 on 19.30 area which corresponding to the 1 bigha 2 katha 4 lesa where DAG number 392 which the petitioner has purchased had 8 bigha 2 katha 10 lesa, and as part of admitted stand of the circle officer dispute Revenue Circle, the same still stand in the name of the petitioner. Under such circumstances, this court direct the circle officer dispute Revenue Circle to clarify the which DAG number, the pattern number of the petitioner land is mutated in the basis of the order dated 6/2/2017 in mutation case number being the case so and so. The said affidavit be filed 4/12/2023 according list matters. But that point is yet to be clarified by the respondent authority. My mutation was cancelled because already there is a earlier mutation order is there. That's why subsequent is cancelled, my lord. All right. Then, my lord, my earlier mutation order is stand, my lord. But they have, on the basis of this order which was passed, my lord, in a demarcation case, the mutation, my lord, my record right has been cancelled, my lord.
Who's for the circle officer?
Lordship, I am appearing.
What have you stated?
আপনার কি নাম নাই
From our affidavit, it reflects as the mutation was already done in the year 1996 and they have again applied in 2014 subsequently. That subsequent mutation was cancelled. But earlier mutation was there, it's still there, according to our affidavit.
Correct. But on the basis of the later one, my lord, they have removed my name from the record. So that's why court specifically asked this question. Then where now that earlier, as per the earlier mutation order, where land is there? Where name of the petitioner? Where is in which place?
Then I have to bring that record, lordship. I have to bring that record. If their name is still there in the mutation, lordship, after the mutation, in the record their name will be there, Lordship. If it is not there, can you make something from it? Original record properly. Eviction is already there. Oh. Wow. And my learned friend said that there is a civil suit is still pending.
The civil suit in different aspect, my lord. This is a question of mutation, my lord. How in the demarcation case, mutation order, cancellation of mutation order passed, my lord.
No, if there was a mutation order already, if there was a mutation
Yes.
already in your name,
Yes, my lord.
then why did you subsequently apply again? For different sort of
Because,
land?
my lord, yes, subsequently in 2000 section, my lord, because it is, my lord, ceiling surplus land, my lord, for abundant question, my lord, again, I have filed it. That's why, correct, they cancel it. But my earlier still exists, my lord. Then, mean, my lord, as per the earlier order, record in the revenue record, my name should be there, my lord. That's why this honorable specifically asked them that, my lord, since earlier mutation order exists, and where is his name, my lord, in the record? Because your lordship kindly see the page, my lord, 27, page 27, my lord, my lead petition, my lord.
Yes.
Last part, my lord. সীমা গোচৰ নাম্বাৰ চৈনছৰ ওপৰত ভিত্তি কৰি চক্ৰ বিষয়া মহোদয়ৰ তাৰিখৰ হুকুম মতে পূৰ্বতে হোৱা ইমান তাৰিখৰ গোচৰ সম্বন্ধে মেছেজ প্ৰবৰ্তন ৰেজিষ্ট্ৰি কৰাৰ নামত নামজাৰি হৈ থকা হেতুকে শেহতীয়াভাৱে এই পট্টা ইমান ডাঙৰ আৰু ইমান নামজাৰি গোচৰ সম্পৰ্কে মেছেজ এয়াৰ ট্ৰেন্সপৰ্ট কৰ্পৰেশ্যনৰ ৰেজিষ্ট্ৰেশ্যন কৰাৰ নামত মঞ্জুৰ হোৱা নামজাৰি ৰদ কৰি নথি সংশোধন কৰা হ'ল। ইন ৰেভিনিউ ৰেকৰ্ড, মাই লৰ্ড, they have corrected, my lord, on the basis of that order which was passed illegally, my lord. I say illegally because, my lord, in the demarcation case, they cannot, my lord, file a cancellation of mutation cannot be done, my lord. Cancellation of mutation is a separate proceeding, my lord. They said that there is a, they applied for demarcation. That's why, my lord, after this honorable court specifically put that question, my lord.
Yes.
By the order dated so and so, my lord.
What do you say?
May please, your lordship. Lordship also cannot see the improving order. It page 23. Second paragraph, my lord. Herein it says, on 22/9/66, the name of the petitioner was mutated in respect of land measuring 8 vega 2 kata 10 acres, my lord. This was mutated in the year 66, my lord. Again, petitioner has applied for mutation, my lord, page 23 and
23.
23, my lord. Your lordship, I cannot see page 21. This is translated copy, my lord. 21.
Yes.
Paragraph 2, my lord. It is seen that the land measuring 8 vega 2 kata 10 acres covered by diagonal so a village of state village was purchased by from Ispagusen by the number so and so. It is seen from the examination of the draft features so and so and DAG number so and so. From DAG number 559. Again, as per final record resulting from settlement operation, the DAG number so and so out of DAG number so and so has arisen. As per present revenue record, land measuring so and so, the 2813 is 19.30 hours. After death of seller, Ispagusen, his heir, Ispagusen, Mir Asif Hussain, was recorded Patadar. So, my lord, as per this report, their name was mutated long back in the year 1966 in respect of land measuring 8 vega 2 katas, my lord, and 10 lessons. Again, they have applied for mutation of their name in respect of land measuring, my lord, 19.30 years in place of legal heirs of original Patadar, my lord. This mutation was cancelled, and this mutation still holds the field, my lord, which was passed in the year 1966, my lord. Furthermore, your lordship, I cannot see paragraph 14.
14 of?
Paragraph 12, my lord, of read petition. Read petition, my lord. Paragraph 12, my lord.
12.
12, 1, 2, my lord.
Yes.
with due course of time, the petitioner got to know about various illegal acts of respondent number 1. Therefore, the petitioner instituted a suit for declaration and permanent injunction against respondent number 4, which is pending in the court of Municipal number 1, Guwahati, as TS number 20417, along with an injunction application for injunction, which is pending as means case number 12 before Municipal number 1, Guwahati. The learned Municipal number 1 has passed an order on 18/9/17 in media case number directing both the parties to maintain status quo in respect of the suit land, state land covered by the number 2815. My lord, in respect of entire land measuring 8 bigger 2 kata 10 acres, they have filed a civil suit seeking declaration of title. That is yet to be decided by the Capital Civil Court of Law. If, my lord, that is decided in affirmative, my lord, then everything goes. They have to succeed in this suit, my lord. That they are having right title interest.
So suit is for what purpose?
Declaration of title, my lord, in respect of the same land.
Which
And
land?
permanent
8 bigger
injunction.
2 kata 10 acres.
My lord, now, my lord,
Who has filed the suit?
I file a
Present
suit,
petitioner.
Why have you filed the suit?
because my lord, they are disturbing me, my lord. That's why, my lord, for permanent injunction. His father sold me a registered settled in 1966. I am not on that. That will take on course, my lord. The order impugn, which was I have, my lord, challenged, that is a illegal order. That's why I'm before your lordship. That was a, my lord, in a case, my lord, they said for demarcation, how that mutation has been cancelled, my lord. And mutation, if mutation has been cancelled, my lord, then, my lord, they should have a notice to on me on that case, my lord.
No, this was pursuant to joint verification, I think.
No, my lord, that is in respect of, my lord, they have not paid for, my lord, cancellation of mutation. And in fact, my lord, your lordship kindly see, my mutation has been cancelled because there is, and already there is a mutation order is there. So if already there is a mutation order, then, my lord, yes, they cancel it, rightly cancel. Yes, they have a jurisdiction. If they have a jurisdiction, they cancel it. But on the basis of that, how they remove my name from the record of right, my lord? That cannot be done, my lord. Now, my lord, my name is nowhere, my lord. Where? That's why this honorable court specifically asked them that where is his mutation, in which place his name is, my lord, recorded.
And this happened during the currency of the title suit.
No, my lord.
Then?
Your lordship kindly see.
When was the title suit filed?
Yes, title suit filed in 2017, my lord.
Then this order is passed in 17.
My lord. No, that's why, my lord, if that order is not interfered, my lord, then it will be affecting my foot, my lord. Because now I cannot pay revenue, my lord. No, my lord, your lordship kindly says justice. That's why, my lord, your lordship kindly, they have not even complied with the order of this honorable court, my lord.
All right, you specify the
Lordship,
area of the land as per the.
My lord, I'm submitting respectfully, my lord, mutation over the land, name over the land measuring 19.30 R has been cancelled, my lord. Because in this, over this plot of land, the name of the
No, his
respondent number.
grievance is that if that we so, and so far as that 8 bigha is concerned,
No, my
his
lord.
name ought to have been there.
Yes, my lord, that is not there, my lord. Everything goes.
That is different. That is different land, my lord.
No, but his name is not there in the records. That's the whole.
That must they can prove, my lord,
that
revenue
is
or
what
can so.
they
No,
were
my lord, because
supposed to find out.
that petition was granted in India 1966, that still holds the field. This land is different land from their 8 bigger 2 kata 10 acres of land, my lord. This was leftover land of the Patasar. Over this land, I am having, respondent number was having.
My lord, this matter is pending since 2017, my lord. Till today, he has not filed affidavit. Now, my lord, he says a different land.
Someone has filed, respondent, who's
Respondent only, my lord.
Lordship, we have filed wherein in paragraph 4, we have specifically mentioned that the later mutation that was cancelled.
No, that's right. But the direction of the court earlier.
Lordship.
That you endeavor to find out and place it before the court, that will
Lordship.
decide the issue.
Yes, Lordship, I will place it.
And you are appearing for respondent 4.
I am 4, my lord.
You are have you filed any counter?
No, my lord, I have not filed it.
Heard learned counsel for the parties. Although the respondent number.
I am for 1, 2, and 3. Oh, sorry.
Respondent number 3 has filed an affidavit.
2 and 3, Lord.
Respondent number 3 has filed an affidavit. The same does not reflect the name does not reflect the tag number and pata number of the petitioner's land, which was mutated on the basis of the order dated 6/2/1997, sorry, 1970, in mutation case number KP case number 1292066-67. So this was directed to be reflected in the affidavit by order dated 8/11/2020. Stop. Mr. H. Sharma, learned Common Advocate, appearing for respondents 2 and 3, submits that you would like to call for the relevant records and place it before the court for perusal, and thereafter make necessary submissions if so required. Mr. Ontol, and senior counsel for the petitioner, submits that this particular issue, if clarified by the respondents, will determine the will be necessary for determining the prayers made in the writ petition. Stop. Counsel for Mr. Alam, counsel appearing for respondent 4. Does not file an affidavit, he is permitted to file an affidavit if so advised by the time. Let the matter be listed. The authority board.
Question number 1. Our name may be
May-
reflected in the court. Our name may be.
May I pray after vacation?
After vacation, Mr. Mon.
No, let them, my lord, clarify that.
19th July.
Yeah.
MSD authority board. List report.
Not much.
28.
Please, your lordship. Lordship, matter may be passed over for today.
Matter stands passed over for today. Listed next week. After a week. 29. None appears for the petitioner. This after a week. Mr. H. Sharma for the respondents.
Please, your lordship, my lord, before starting my petitioner side, my lord, I am appearing on behalf of the respondent. I was allotted, granted some land, my lord, land allotment, and that has been challenged. They are making allegation that before granting the allotment, due process was not taken, my lord. They are not hard, but it was duly, my lord, hard. There was a verification, spot verification, hearing also. They are objecting that it was not duly done. And they are also raising a point that under the land policy 2019, one can be granted only 3 acre land. And land granted, my lord, 9 acre to me. My lord, all these issues, my lord, my proposal is, my lord, my submission is that, my lord, let the matter be remanded back to the VTC for taking a fresh decision instead of pending here, my lord. If granted me only 3 acre, curtailing the, my lord, the allotment from 9 acre.
Who is the petitioner? Why are you objecting?
My lord, now, just now, my learned friend has given a proposal. My lord, if it is remand back, then this Annexure 5 order dated 9 July 2021 may be set aside and.
Why are you aggrieved?
My lord, I am agreed because I am in possession of the land without consulting me, without hearing me, this order was passed.
Where is that order?
Page, my lord, 34.
And the LOT is represented by you.
My
And Borolan, what do you say?
Lordship,
As for record purification, Lordship, I also think that some lapses were there, Lordship, by allotting 9 bighas of land, Lordship. So, Lordship, if Lordship remand back to the authority again decide the matter, Lordship, it will be better, Lordship.
You have paid the premium.
Yes, my lord, we have paid the payment and
If you redecide, you have
land
to
is.
give back the premium also.
Lordship,
Yes.
that may be.
My lord, they are raising that as per the land policy 2019, only 3 bigha can be allotted. This land area allotted to me is 9 bigha, my lord.
Those readings were completed, Lordship. After verifying the records, I also.
What do you submit?
My lord, if your lordship set aside the impugn order and remand back for.
If I have to set aside, I have to hold it to be illegal.
Because
there has to be a finding that it is illegal or unauthorized.
Yes, because as per land policy 2019, it is only 3 bigha. And thereafter it was again revised to 2 bigha. So there is a lapse. It is admitted by both the parties, my lord.
No.
Where is the admission?
No admission.
No admission. My submission is that if it is reduced to 3 bigha, I am ready to accept. And the repayment of the refunding of my balance amount. If it is reduced to 2 bigha, then also I am ready.
Third learned counsel for the parties, the petitioner is aggrieved by the impugned order dated 9th of July 2021, by which area of land measuring 9 bighas, 1 quota, 3 lectures have been allotted to one Chinu Nursery, Srimati Chinu Nursery, who's the private respondent number 5. And who is number 6?
Well, I'm for the respondent 6.
What grievance you have against 6? Respondent 6?
My lord, 6 is supporting the petitioner.
Because
My lord, all are of
six is
same family, my lord.
Same family members.
All are same family, my lord. Respondent 5.
You have no grievance against 6.
I have no grievance against.
Why we made 6?
Why not? I have only grievance. By that point of time, he was not with me. That is why I made him party.
Okay. So and so, it is for respondent number 6. So, the counsel for the petitioner submits that as per the land policy, at present only 2 bighas of land can be allotted to persons. Stop that apart. Land which is allotted to the private respondent number 5 is the land on which is under the possession of the petitioner. Therefore, without issuance of any notice, the petitioner, impugned order by the PTC,
No bigha,
not have been issued.
no bigha, man lessa.
He is there, he being aggrieved has approached this court, praying for appropriate redirection order. The respondents have filed their affidavits. Respondent number 3 has filed the affidavit contesting the case for the petitioner.
No bigha, ekata 3 lessa.
Although notices have been issued today when the matter is called up, counsels appearing for the parties are in agreement that the matter can be directed, matter can be remanded back to the to whom?
PTC authority.
Which authority?
Secretary, Land and Revenue.
The respondent number 3, namely the Secretary, Land and Revenue, and what is HD?
Okay.
HD department?
Land and Revenue.
Borderland Territory Council.
Actually, it should be.
Land and Revenue for
Land and Revenue.
Council to redecide this issue of allotment in respect of respondent number 5 and pass appropriate orders if called for, keeping in view the land allotment policy framed by the state. Stop.
Actually, it should be CHD, Council Head of the Department.
If such an order is passed and in the event the PTC authorities decide that lesser amount of land, the PTC authorities decide that the land allotted to the writ petitioner to the respondent number 5 by impugned order dated so and so needs to be revisited and a separate land or a lesser amount of land is required to be allotted, then the amount of premium stated to have been paid by the respondent number 5 should be refunded or adjusted accordingly. So the PTC authorities will examine the claims of the writ petitioner that he was in possession of a land of 9 bighas, 1 quota, 3 lectures,
My lord, so far, well, the claim of possession, my lord, we have objection, my lord.
covered by TB number 37, tag number 1, situated at Chanmari seat, Kotopa Cultural Complex, Kokrajhar, under Post Office and Police Station, Kokrajhar, Revenue Circle, Kokrajhar, District, Kokrajhar. So, the respondent number 3 will proceed to rehear the matter and take into account the objections raised by the writ petitioner and obligor the private respondent, and thereafter pass appropriate orders. Stop. The entire process be completed within a period of 60 days from the date of receipt of a certified copy of this order. Stop. Till the matter is decided, the respondent number 5 is directed not to alienate the plot of land allotted to the petitioner in respect of allotted to the petitioner by the PTC by the impugned order dated 9 July 2021. Alienate or create third-party rights on the plot of land. So, the PTC authorities, after hearing the petitioner and the respondent 5 and 6, will pass a fresh order deciding the issue, and a copy of such a speaking order shall be served on all the affected parties, including the writ petitioner, respondent, and respondent number 5 and 6. Stop. If the PTC authorities pass an order the PTC authorities, after hearing the matter, passes an order upholding the impugned order dated so and so, then the petitioner would be at liberty to utilize the land under the provisions of law as permitted. Writ petition accordingly stands allowed, disposed of. No order is proposed, interim orders, if any, stands vacated.
Yes,
3 months,
My lord.
90 days from the date of receipt of a certified copy of this order.
I think 31 to 36.
But here my instruction is everything matter, we'd like to file an affidavit. Can it be after 4 weeks?
So this matter is covered and earlier also series of matters have been disposed of. And the department also agreed that this is covered.
No, I am not aware of that order. Well, in that case, the copy will be served to me and it may be posted next week.
What is the matter about?
From the
That is made of the. Not in 32 year of CBC.
Hmm.
The matter is that the assessment was not completed. And thereafter the reassessment was completed on the ground that the self-assessment has been deemed to be completed. Now for the conditions for self-assessment is that, my lord, all the monthly returns and annual returns must be submitted in time and the tax must be paid within time. And we have given the chart here that the monthly returns were not submitted within time. Now following that, my lord, same logic in Assam Gas Company, my lord, the reassessment order was passed, and following that, my lord, about 10 petitions were also allowed where the department agreed that this is covered.
Yes.
Next week in that case. Or the week thereafter.
We'll have it on 4th. You get your instructions. If it is covered, we can close it.
It will be submitted, your lordship.
17 minutes. On 7 minutes. 7th of June.
Yes, okay. Leave it on 7. Let him get his instruction.
Unless it's the case of pending, you know, these are matters of 2022, and the appeals are not filed. And the matter is covered in other cases, when they say that it is covered now. Instructions.
Third learned counsel for the parties. This petitioners are aggrieved by the reassessment orders passed by the authorities without having a prior assessment made. So petitioners say that the reassessment orders passed are contrary to the provisions of law, and has therefore approached his court praying for appropriate redirection of it. Learned counsel appearing for the petitioner submits that the issue stands covered by orders passed by this court in WPC 7725
Which were following without earlier division bench judgments, number of judgments.
dated 2004-2024 and WPC 5858 of 2018 disposed of on 2/4/2024. So copies of these orders have been furnished to the Learned Standing Council, EST. Under the Learned Standing Council submits that he would like to complete his instruction in this kind of, and submits that the matter be listed again on 7th of June.
7th June.
Accordingly, let the matters be listed on 7th of June. Matters to be treated to be partnered. Yes.
Wait, please, Lord. Lordship, on the last occasion, a senior friends take time to file their response. The response has not been filed. Necessary to adjudicate the matter.
Any affidavit file?
Private respondent has filed.
Private respondent has filed, my lord. It is not being said, not that filed, because I have not got all the entire instructions. Look, only we are on that private respondent has filed an affidavit, detailed affidavit, but he had not annexed the NOC. That's the difficulty I am facing, my lord.
Who is not annexed?
My lord?
Who is not annexed?
Private respondent.
Private respondent number 5.
That NOC will make it clear, my lord, whether this is a residential or a commercial building. And he is running a commercial establishment.
Yes.
Lordship, we have filed.
No, but no NOC. Why don't you enclose the NOC?
NOC of the building, the moment the NOC building
You
comes from
produce the
record,
NOC.
everything will be clear.
A specific response on the GMC is required because
thereafter, my lord,
is getting delayed because Lordship will kindly pay.
It must be available in your record.
But
Yes,
it is available in our record, but this particular building has this NOC that we cannot detect it. Man. That's why we gave a notice that you please provide me the NOC of the building. Then we can say that the building is a residential, commercial, or what is going on there.
But
The
is there no record in the GMC office?
Yes, there is a record, but we don't know that particular building has this particular NOC number and record is this. This is the record. That's why we issue notice to the petitioner that you give the NOC and other documents. Then we can locate the record. Being a building, we cannot get the NOC of the building.
Third learned counsel for the parties. Although the opportunities have been granted. The GMC authorities have not filed their counter affidavit. Mr. S. Bora, Learned Standing Counsel, GMC, submits that the difficulty submits that although notice have been issued to the respondent 5, private respondent, but the NOC has not been furnished. So he also submits that the respondents have filed, a private respondent has filed a counter affidavit, but the NOC in respect of the building has not been entered. So, the relevance of the writ petitioner is that the respondent number 5 is running an enterprise illegally without
Obtaining the license of the godown.
obtaining the license and permission from the concerned authorities. So, in that view of the matter, let the respondent place before the court the NOC penny
So now
granted
five,
by the GMC, respondent number 5, by the next date fixed. I hope the matter will be listed on. When can you file it? 21st? Listed on 21st of June.
Moment the NOC comes, it will be clear, man, whether the residential may be used, maybe using as a commercial activity.
We'll see. Okay.
Meanwhile, they may file
GMC authorities is also permitted to file their affidavit in the meantime.
Please, Lordship, kindly pass out for the matter for timing.
Matter will be listed next week. At the council, at the request of council for the petition, next week.
Sir, I'm sorry, my lord, this item escaped from my notice, my lord. Tomorrow or
At the request of the council for the party, matter be listed next week. Next week. Request for the council for the petition. None appears for the petitioner. List next week. Next after a week.
Yes, Lordship. The affidavit in opposition is still awaited, my affidavit in opposition, my.
So do we may be given 3 weeks time to file that.
MS S. Sari, Learned Council, prays for 3 weeks time, further time to file the affidavit. Mr. S. Dotto, Senior Counsel, appears for the respondents. The prayer of the respondents, matter stands adjourned for 3 weeks. Mr. B. Kumar,
My lord.
appears for the petition.
Repeal, Lord.
Yes.
The matter will be taken up at 2, Lordship. Or on Monday, Lordship.
Monday.
Monday? Just on Monday.
I pay for some time to file my appeal.
Mr. S. S. Roy, Learned CG, Learned or BTC?
BPCL.
Huh?
Bharat Petroleum.
Bharat
BPCL.
Petroleum. Appearing for the Bharat Petroleum Corporation Limited, brings for further 3 weeks time. Prayer is allowed as the counsel for the petitioner is not present. Please take. Yes.
But this matter may be taken up at 2, Lord.
Why?
But Mr. R.M. Das will do this matter.
Admitted matter, Lordship.
Admitted bills. All right, at 2 o'clock, second half,
Look,
second half,
Lordship, this will take some time because my lord,
okay.
the complete hearing is there.
It says admitted dues. These dues are admitted.
No, it's related to land acquisition.
land acquisition matter, Lordship, Deputy Commissioner has already.
We have filed the detailed affidavit, my lord. This will take some time.
Well, we'll have it on 4th if you want, or on 11th. 11. Had to be listed on 11th. Or at the request of the council for the party. 11th of June. Yes.
They're supposed to obtain instructions in the matter.
Who's for the respondents?
There is them.
Mr. Gupta appears. Misra
My lord.
appears for the petitioner. None appears for the respondents. Matter stands declared listed after 2 weeks. In order, past it will continue.
Deeply obliged, my lord.
Your Lordship.
Yes.
Lordship, the last order 3/4/24. I am representing respondent number 4 in this case, my lord.
Who's for the petitioner?
R. Sharma representing the
None appears for the petitioner, Mr.
In this case,
Kedekar.
my lord, in petitioner as well as other respondent supposed to file affidavit, my lord. My affidavit is ready, my lord, for the respondent number 4, my lord. I have sent it to the Hyderabad to get the affidavit there. So I am praying for further times.
Mr.
May it please, Lordship, I am to the petitioners. We are filing a rejoinder in the course of the day against the state. R4 is the association.
Yes.
Senate counsel appearing for the petitioner submits that they are filing the rejoinder in response to the affidavit filed by the state. You are filing it today,
Yes, Lordship.
filing it in the course of the day. Stop. The respondent number 4, meanwhile, seeks further time to file the affidavit on their behalf. He prays for
2 weeks, my lord.
2 weeks further time. Any objections? 2 weeks further time. List accordingly.
So don't focus on two, focus on two.
Yes.
In this case, state as well as central board has issued notice.
Sorry.
State as well as the central GST, both have issued notice. There should be only one from either side.
So,
My lord, we have communicated with the department, my lord. Instructions have been awaited in this matter.
so there is a clash between the departments.
Yes, my lord.
That is a good ground for interfering with both.
One notice will remain. That is the topic for.
So you decide which
Yes,
one will remain until let me interfere with both and send it.
as per the section of the operative who has initiated first, that will. Legal, my lord. That will.
This is against what?
No, this is against the, my lord, proposed notice issued by the, my lord, center, my lord.
Then state has also issued.
State had issued state firstly said issued, my lord. Thereafter center issued on the same figure, same financial year, my lord.
It has to be the state only,
My lord.
technically.
Just have instruction.
Third learned counsel for the parties, the respondent counsel submits that some clarifications are required from the respective departments as for the same issue. 2 separate notices have been issued, one by the state and one by the state GST and the other by the central GST. Accordingly, let the matter be listed again after 2 weeks, enabling the respective respondent counsels to complete their instructions. Mr. R.S. Mishra appears for the writ petition. After 2 weeks.
No, interim order may kindly be continued.
Interim order passed early will continue.
Oblige, your lords.
opinion of the petitioner here, office was to get the respondent number for one access they is appearing. Uh,
Who's appearing?
for central government assessor was appearing. Controlling authority under the Wages Act, nobody has appeared. All the notice has been served on that.
As per office note, respondent 1 and 2 has been shown to have been served the notice. However, none appears. Payment of gratuity, I think Mr. NC Das appears.
No, Lordship, that is with regard to tea garden and another.
Okay, who's for CGC will appear here?
Lordship,
No
for-
CGC.
Nobody is appearing, Lordship.
All right.
They have to engage their company.
However, none appears. Accordingly, matter be listed after 2 weeks
For admission.
for admission.
Macho.
You also may pray for item 44. Government said that they're supposed to file the affidavit. They need some time, so some date may be fixed.
It has already been. We have already ordered. You should have been here at the time.
I'm just yes. Sorry for.
I think 15 I have received instruction of you have to file affidavit.
Mr. R.N. Mishra for the petitioner, Mr. S.C.K.L. for the respondent counsel, Mr.
H. Purva, my lord.
H. Burwa appears for the H.
State
Burwa and S for state TST, Mr. S.C.K.L. for central TST. Mr. K.L. submits that instructions have been received. You'd like to file an affidavit praise for 3 weeks further time. It's after 3 weeks. Interim order passed on, you will continue.
Leave to oblige, my lord. 51. So 51 is same.
Same order.
Deeply obliged, my lord.
There is an interim order.
My lord. Deeply.
52. In this case, my lord, government allotted land, my lord, in the year 1988, my lord, and it was mutated also, my lord. Subsequently, government issued one letter, my lord. By way of this letter, my mutation order has been cancelled, my lord. We have already challenged in another case, my lord. That judgment is fully covered with the same case, my lord. I have annexed here. And now I want to place the case, my allotment letter, page 20. Annex 2, my lord.
No, who's for the respondent?
Respondent, my lord.
Yes.
Allotment correction of land records in accordance with the provision of contained in the circular dated in the year 1988. The land records in respect of an area of the land measuring 1 katha 5 lessa.
Yes.
Covered by Dag number so and so, Bizni Raj State, Toji number so and so in the Ohapuri town held by Prasanna Kumar Kulita, son of so and so. Under Bizni Raj State since long been before acquisition of land under the acquisition of the Zamindari Act may be corrected in the name of Prasanna Kumar Kulita, son of late Haran Chandra Kulita as regular dole as to the land. Thereafter, my lord, it was mutated. Original copy I have annexed here, my lord, page 23.
158.
Page 23.
Yes.
English translation is, my lord, page 22. Pursuant to letter number so and so, dated so and so, the additional deputy commissioner de Bongagao, an order of the ASO Seasongram Circle, dated so and so, the records of the plot of land corrected by Dag number so and so, Patta number so and so, is corrected in the name of Prasanna Kumar Kolita. It was in the year 98, my lord. And land
Where is the notification
yes, my lord.
16.7?
That is, my lord, Annex 5, page 26. That has been settled.
This was set aside.
Set aside because
By which order?
By order, I have annexed here, last page 41, annexation 9, relevant portion, my lord.
paragraph, my lord, last paragraph, that is paragraph 7, page 48. And followed by the said order also, my lord, this is my lord, Kolyan Purana,
This is in which matter?
in another case, my lord, following similar order, short order.
You have approached the authority pursuant to this order, page number 50, pursuant to direction at page 50.
Page 50. Yes, my lord. The same as it is, my lord, because my lord, allotment given, my lord, allotment order given, subsequently it was mutated, subsequently without our knowledge, my lord, they have, my lord, issued this impugn letter, my lord.
Which letter? Page?
16.7, my lord.
Page.
Page, my lord, impugn order, page 26, annex 5, correction of brand record. And we also filed, earlier also we filed petition. In the year.
No. This was set aside.
Set aside.
By this order. By this order.
Yeah, last order, my lord. Earlier, my lord.
No.
Earlier,
Listen. Kindly listen to the court.
Yes.
Your annexure 5, page 26, you had approached this court, it was interfered with.
Yes, madam.
By this order.
By this.
And para 8 of this order at page 50,
Para 8 of the order.
you were permitted to approach the respondent number 4.
Yes, my lord.
For seeking mutation.
Yes, my lord.
What happened after that?
It was mutated, my lord.
Mutated.
Earlier mutated, subsequently cancelled by this letter.
Then?
Then I have to come before this honorable court. And again, the specific order was required on required, my lord, because this order, unless this order is set aside, 16.7.99, they cannot.
What was set aside by the order?
By the order, my lord.
16.7 has been interfered with.
Yes, my lord.
What are you saying?
Yes, 16.7.99 has been interfered with.
Then,
my lord, this requirement is that, my lord, as it was earlier mutated, and by this impugn order, it has been, my lord, become cast length. In view of this order, petitioner need for correction of this record.
You have been given liberty at paragraph 8, page number 50.
This one is for another person, madam. This case is filed.
Oh, this is not for you.
Not for me.
Okay,
It is proper judgment, that's why I have annexed.
okay.
One Brindavan Chaudhary and Adit Chandra Rai, they were also similarly situated. And this order has been, my lord, yes, this is also another person.
All right. Yes, what do you say, respondents?
On a similar line, may look for the.
All right, heard learned counsel for parties, petition stands disposed of. To the order as a time. Covered, page number 42 subsequent order. And the parent will be setting aside will be page number 26. Be prepared. Set aside. All right, we'll pass notice.
Oh, yes.
May I please? So this petition has been filed praying for direction to grant mutation on the land of the petitioner. In fact, Lordship, the same similar issue has already been decided by this honorable court. A part of the land was purchased by another person on the same duck number and pata number. He was not granted mutation on the ground that the land falls under FS grant land. Subsequently, Lordship, this honorable court has disposed this petition directing the authority to grant mutation. Accordingly, mutation has been granted in respect of another person. And another part of the land from the same duck number has been purchased by me.
Where is that order?
My lord, I have annexed that order, that is page 47. Same duck number, same partner number, same area of land, 2.26. Page 4.
Okay, get your instructions, let us see. Let them go obtain their instructions.
Page 51 is the.
That's
mutation.
okay, but we'd like to get
My
some
lord.
instruction from the respondents. Who appears for the respondents?
We have from the District Commissioner Office, a communication was sent to government lordship regarding these mutation cases and all along with all records. And from approval from the government is yet to receive
Approval for what?
for grant of mutation, page number 35, annexure 6 of the petition.
In fact, the government has already returned the proposal in respect of other person to page 37, saying that the district commissioner is the competent authority.
At the page number 37
37.
is earlier of this communication.
Yes, Lordship, that was in respect of another person. That is the order, Lordship, that we have annexed in respect of that page 37.
But
These are on the basis of what? Sale deeds.
Sale deed,
You have purchased it.
my lord. I have annexed the sale deed also, and the DC permission before Lordship, the sale deed that was obtained and granted by the deputy commissioner.
So what is the stand of the government in respect?
So my understanding.
What do you say?
The instructions are awaited. We have written to the department, but no instruction received yet.
Let them get
This
their
has come for the second time only.
The instruction page 37 has already been given by the government.
What?
page 37. That was in respect of another personal lawsuit, that order lawsuit that we have alleged. Government is already saying that last paragraph.
Hmm.
As per government circular dated so DC will take step to convert the national grant into.
So get instruction from the DC.
I'll get
From the DC, find out.
This is
will
regarding,
get-
this
she will
is
get.
regarding another co-pastor, lordship, not petitioner.
That's right.
Yes.
But the revenue disaster management says it is the DC who has to take a call.
Yes, lordship, we have communicated and over telephone, they said that from approval from yet to receive from government. That's why.
The government says it is the DC who has to do it. Have they done whatever is required to
Then
be
I
done?
will take instruction regarding this.
All right, heard learned counsel for the parties. This petitioner is aggrieved by the inaction of the respondent authorities in not mutating the name of the petitioner on a plot of land which the petitioner has purchased by virtue of a sale deed executed by and between the petitioner and the purchaser of the land. Plot of land measures 16.89 lechas, covered by tag number 400 and KP Patta number 1 at Revenue Village, Sohor, Kharguli, Moza, Ulupari, Ward number 34, Central Zone in the district of Khammam. So the particulars, schedule of the land is provided in the sale deed. So learned counsel for the petitioner submits that all particulars and procedures have been complied with. However, in spite of that, the Deputy Commissioner Kamrup Metro is not proceeding to mutate the land in the name of the writ petitioner on the basis of the sale deed executed. Stop. In a reference to the mutation sought for by another similarly situated person, a communication dated 23 February 2022 was issued by the Joint Secretary to the Government of Assam, Department of Revenue and Disaster Management, the Deputy Commissioner, to show wherein it was stated that as per Government Circular number RRG .10 slash 2001 slash 3 dated 16/8/2002, it is the DC who will take steps to convert the instant grant into the T periodic patta, so long as it fulfills the conditions of special cultivation or otherwise may convert simple Kirat Miyadi patta as a whole, considering the sealing provisions of the 1956 Act. Stop. Learned counsel for the petitioner submits that even the Revenue Department has opined that it is the DC Kamrup Metro who is required to complete the procedure and grant mutation. In spite of that, no steps have been taken. Where Mr. A. Bhattakur, A. Bhattacharya, learned counsel for the Revenue and Disaster Management, as well as Ms. S. Porua, learned government advocate, jointly submit that they will complete their instructions in the matter and they be permitted some time. Let the matter be listed after 2 weeks. List according.
Paper date law.
After 2 weeks. 19th. At 2.
Shilapathar Municipal Board, my lord. My lord, a no confidence motion was brought against me and the requisition for bringing the no confidence motion was given to the Deputy Commissioner in the month of December 2023. My lord, the Deputy Commissioner asked us to convene a no confidence motion. My lord, we did not convene a no confidence motion because Deputy Commissioner has no power under the Municipal Act to direct us to convene a no confidence motion. Thereafter, my lord, the ward commissioners who have brought the no confidence motion, they have filed a writ petition before this court.
My lord, I am appearing on KBH.
Huh?
I am appearing on KBH.
KVA.
On carry. Mr. R.P. Sharma. Senior counsel assisted by Mr. For the caveat. Caveat, Mr. Yes.
My lord, we said we cannot call a no, I said that I cannot call a no confidence motion on the direction of the Deputy Commissioner because if a no confidence motion has to be brought against me, then the requisition has to be given to me as per the mandate of the Act. Therefore, I have not called it. They filed a writ petition before this court, my lord.
Mandate of which act?
Assam Municipal Corporation Act, Municipality Act. Now, my lord, the issue is not this, my lord, because this issue was settled in the writ petition. Thereafter, my lord, they filed a writ petition before this court saying that we are acting in violation of the Act and also saying that we have not allowed them to participate in the meeting which the Vice Chairman has called to discuss the no confidence motion. My lord, that writ petition was disposed of with a categorical finding that the manner in which the no confidence motion is brought against the chairperson is not in accordance with the Municipality Act and it is illegal. The manner has been declared to be illegal. However, my lord, as an observation of law, not as a direction, it was the writ court held that there is no bar in calling a second no confidence motion. This failed that there is no bar in calling a second no confidence motion as an observation of law, not as a direction that you call a second no confidence motion. Now, they, after the disposal of this writ petition, in the meantime, my lord, there is one fact which I must say that the date on which the first no confidence motion was fixed, that no confidence motion failed against them because they could not turn up in that no confidence motion meeting. However, they alleges in the writ petition that they could not go because they were stopped, they were kidnapped, etc., etc. My lord, that the resolution taken in that no confidence motion was again put to challenge by them in a writ proceeding which is pending before this court. The resolution of the first no confidence motion is still pending before this court. Now, this is the second no confidence motion which they have called. Now, this time they have given requisition to me. I called a no confidence motion. I said, fine, three of them, the Act says that 3 members, if they give a requisition, then I am duty bound to call it within 20 days. I have called it within 20 days, my lord. I have called a no confidence motion. The executive officer writes a letter to the chairman. He says that now since the model code of conduct is in force till 4th of June, don't call a meeting to discuss a no confidence motion, cancel it, withdraw it. Because we as an official cannot be present in that no confidence motion meeting as an impartial observer, because the house is divided now. So as an impartial observer, we cannot be, government official cannot now attend the no confidence motion meeting, so you cancel it. Accordingly, we cancel that no confidence motion. The moment we cancel that no confidence motion, the vice chairman, with 2 days of notice, on 27th, the vice chairman issues the notice that you failed, therefore I am calling a meeting. On 29th, 27th notice, 29th meeting. On 28th, I write to them, to all the ward commissioners, that see, I am not shying off from a no confidence motion. Model code of conduct is there. MP and MLA are the ex officio member of the municipal board who has a right to vote. Now the MP and the MLA, because of this election, they cannot participate. But they were in a hurry because in the last meeting, the MP and the MLA, they have supported us. So they want to remove our support base. Somehow before 4th, within 2 days notice, they convene a no confidence motion meeting against me, my lord. On 28th, I say that I will call it, just wait till 4th. On 4th, the result will be out. We are on 29th, hardly 5 days. No heaven will fall on earth. Notwithstanding that, They convene a no confidence motion with 7 members out of 14 ward commissioner. They pass a motion, no impartial observer, nothing. They pass a resolution that the present petitioner we lost confidence and he's gone. He is no longer the chairman. Now there is an executive order which says that when the model code of conduct is in force, only meeting of emergent nature or day-to-day routine activities meeting can take place. Only day-to-day routine or meeting regarding some emergency matter. Now, I was trying to figure out, my lord, what does the emergency meeting mean under the Municipal Act? That took me to section 247 of the Municipal Act. Section 247 of the Municipal Act says that emergency is public safety and public health. Suppose some cholera or malaria or some disease broke out. That is an emergency. Some drain damaged, water spilling over, some chaos in the town. Those are emergencies. But no confidence motion is not an emergency meeting, my lord, as such. We just said wait for five days. Let the MP and the MLA, let the election results be out by 4. MP and the MLA, because they are the ex officio member, they have a right to participate and vote. These are not in dispute at the bar also, my lord. On the first writ petition, all these were settled. The only issue before this writ court in this writ petition is this, my lord, that whether during pendency of a writ petition pertaining to the first no confidence motion, whether the second calling of the second no confidence motion is valid, number 1. Number 2, whether at the face of this administrative instruction, which says that during the currency of that when the model code of conduct is in force, no meeting except meeting pertaining to day-to-day routine or emergency meeting, whether during the while the model code of conduct is in force, whether they can call for a special meeting to discuss the motion of no confidence against the chairman, and whether in the absence of any impartial observer, a meeting held in a clandestine manner can be held to be a valid meeting, my lord. That's my humble submission. I take your lordship to the relevant annexures now, my lord. I'll first show the order of this court where the first no confidence motion failed, my lord. My lord will kindly come to the notice of the first no confidence motion. Your lordship will find at page number 23.
Yes.
This was to the Deputy Commissioner Dhemaji, letter of no confidence motion against the chairperson.
You show us from the act versus the provision.
My lord. My lord. My lord will kindly come to section 28, removal of chairman and vice chairman.
The Municipal Corporation Act.
No, the Assam Municipality Act.
Assam Municipal Act.
No, it was second 28 amendment.
More than half of it.
More than half of
It is then half.
Yes, sir. More than half. Not
Yes, 28.
28.
Now, there is amendment in 2011, effective 2012.
I'll indicate that. I'll indicate
In
that.
section 28.
Yes,
there
I'll
is
indicate.
that earlier it was not less than half, it should be more than half.
Now,
More
my
than
lord?
half.
Not less than half.
That has been amended in my lord.
It is more than half now.
Now more than half.
Now, in all books, it is written less than half.
It was amended far back in 2012. Yet
This amendment has not been
Simply
incorporated. There is no dispute
compilation.
at the bar, my lord. This is more than half. Now, my lord, section 28, subsection 2. An elected chairman or vice chairman may be removed from his office by resolution of the board in favor of which more than half, I am reading it as more than half, in favor of which more than half of the whole number of commissioners shall have given their vote at a meeting specially convened for the purpose. This is that a meeting specially convened where more than half will have to vote. Now, this takes us to the provision of special meeting as to how a special meeting has to be called. Section 43. My lord, I am only reading the relevant.
So what are the meetings to be conducted?
My lord will kindly come to page section 43.
No, 43 is special before that.
No, ordinary and special. 43 is ordinary and special.
43. Yes.
My lord. Subsection 1. The commissioner shall meet for the transaction of business at their office at least once in every month, and as often as a meeting shall be called by the chairman or in his absence by the vice chairman. My lord is there, my lord?
Yes.
Yes, that is an ordinary meeting. If there be no business to be laid before the commissioners at any monthly meeting, the chairman shall, instead of calling the meeting, give notice of the fact to each commissioner 3 days before the date which is appointed for the monthly meeting. Now comes 2. The chairman or in his absence, the vice chairman may call a special meeting whenever he thinks fit, and shall call one. Now, my lord, this is important. And shall call one on a requisition by not less than 3 of the commissioner. So if more than 3 commissioner makes a requisition, then mandatory, shall call one.
3.
3.
Not less than 3.
Not less than 3. And shall call one on a requisition by not less than 3. So 3 and above. Now, number 3. If the chairman or the vice chairman fails to call special meeting to meet within 20 days, after any such requisition has been made, the meeting may be called by the person who signed the requisition. Now, my lord, if I understand, a conjoint reading of 43 subsection 2 and 3 is this, my lord, if I understand it correctly, my lord, that if a meeting is called on a requisition by 3 or more members, then the chairman is bound to call a special meeting. Now, my lord, the duration is within 20 days. Now, if the chairman fails to call, if the chairman fails to call or the vice chairman, then the person who has signed the requisition will call one. Now, there is one gray area, the time frame for the second part. If the chairman fails, then within how much time the person, how much time they would give for the meeting to be called? Within 1 day, 2 day, 3 day, 4 day, that time is missing. For the chairman, it is 20 days time laid down. That time is missing. Now, my lord, I take your lordship to section 297, and then I'll come to the facts. This is to buttress my point that what would be emergency situation.
Yes.
My lord, section 297, I beg my lord's indulgence to subsection 3 straight away. If in any case of emergency, the deputy commissioner, upon the recommendation of the concerning technical advisor, immediately available in the district within which the municipality is situated, is of opinion that the immediate execution of any work or the immediate doing of any act which the board, whether at a meeting or other doing of any which the board, whether at a meeting or otherwise, are empowered to execute or do, is necessary for the health or safety of the public, he may call upon the board to execute the work within such time as he may appoint. So an indication is given, my lord, that emergency situations are those situations which pertains to the health or safety of the public. And in that event, even if the commissioner does not call a meeting, the deputy commissioner may call a meeting to address these 2 issues, my lord. probably, my lord, for adjudication of the present writ petition, these are the provisions, my lord, subject to correction, which are germane or relevant, my lord. In addition to, now, my lord, I take your lordship to the order passed by this court against the first no confidence motion, which was called by the respondents. I have shown the requisition, which was at page number 23. Yes, the requisition was in page number 23. Based on this requisition, the deputy commissioner directed the chairman to communicated this requisition and directed him to convene the meeting to discuss the no confidence motion, and eventually, my lord, a writ petition was filed. I skip all this, my lord. I take your lordship to page number 31, the order of the writ court. My lord, it starts with the relevant, it starts with page 34, my lord. Prior to 34, these are cost title and the name of the parties. Para 2. The petitioners herein are the elected members of Shilapathar Municipal Board. By letter dated such and such, 9 elected ward commissioner made a complaint to the deputy commissioner, ventilating their no confidence against the chairperson. This was followed by another letter dated such and such for making an inquiry regarding the no confidence motion. By a letter dated such and such, the district commissioner Dhemaji forwarded the petition submitted by the ward commissioner expressing their no confidence motion against her, that is the chairperson Shilapathar Municipal Board, which is held by respondent number 7, was given 15 days time to hold a board meeting from the date of receipt of the said letter. Accordingly, the vice chairman Shilapathar Municipal Board issued a notice convening a special board meeting of Shilapathar Municipal Board purportedly under the provision of section 28 of the Assam Municipal Act 1956. The district commissioner Dhemaji, by an order dated such and such, appointed Bishwajit Phukon ACS as his representative to attend the meeting. My lord, the finding of the court, I take your lordship, my lord. These are facts, my lord. The report is on. My lord will kindly come to para. Yes, para 13, page number 40. My lord is there, page 40, para 13. Therefore, on the issue as to whether the district commissioner has any power or authority to issue any direction to the municipal board chairman, vice chairman to hold a special meeting for removal of the chairperson or vice chairperson, it is seen from the scheme of section 43(2) of the Assam Municipality Act. Only on requisition signed by not less than 3 members, a special meeting shall be convened either by the chairperson in his her absence. The vice chairperson may call for a special meeting and under subsection 3 of section 43 of the Assam Municipal Act 1956. If the chairperson or the vice chairperson fails to call a meeting within 15 days after any such requisition has been made, such a meeting is permissible to be called by the person who have signed the requisition. Therefore, the manner in which the meeting was convened in this case in respect of board meeting of Shilapathar Municipal Board cannot be said to be in valid exercise of the power. Now, my lord, while disposing of this writ petition, my lord, a passing observation was made at para 17, page 42.
Yes.
Now, while disposing of this writ petition, a passing observation was made at page 42, para 17. Therefore, while the initiation of the no confidence motion against the respondent number 7 is not found in accordance with law, and at the same time, the intervention of the district commissioner Dhemaji and the high-handedness of the officer in charge of Shilapathar PS cannot be approved. The bottom line is that there is no bar under the Municipal Act to once again move a no confidence motion against the chairperson and or vice chairperson. Such motion is not barred. However, it is made clear that whatever action that the respondent authorities intends to take must be strictly in accordance with the provision of Assam Municipal Act 1956, and the prescription of law must be adhered to. So there is no direction that you hold a second meeting. Why I am making this submission, my lord? Because a pleader notice was issued to the petitioner saying that you will be prosecuted for contempt of court.
Whatever, that is irrelevant now.
Now, it is because in respect of the second meeting, which is under challenge now, my lord. In respect of the second meeting, a pleader notice was issued that if you don't convene a meeting, you will be held for contempt of court.
Yes.
Now, my lord, page 43, this writ petition, that's the second writ petition, page 43, filed by them, not by us. Page 43, that's the writ petition. I'll not take your lordship to the other abutment. I'll just show the prayer of this writ petition because this prayer is sub judice before this court. The prayer part your lordship will find at page 65. What is that? In the premises aforesaid, the petitioners humbly pray that your lordship may be pleased to admit this petition, call for the record and issue rule notice on the respondent annex to why a writ in the nature of certiorari should not be issued quashing the so-called proceeding dated 5/1/2024. Meaning thereby that in the proceeding dated 5/1/2024, the no confidence motion which was brought against the present petitioner failed. So whether that resolution or that proceeding is valid or invalid is sub judice. It is their petition. I did not file this petition. They filed it. It is sub judice because pending this issue, they are now calling a second meeting, my lord. This is one. Now, my lord, after the order which I have shown to your lordship, my lord, after disposal of that writ petition.
In this writ petition, what order was passed?
Which one, my lord?
Second writ petition.
Second writ petition is still pending, no stay order, nothing. It is pending.
Yeah.
Though they prayed for a stay order, but the court refused, there is an interim prayer here. Now, my lord, after the order passed in the first writ petition, they issue a fresh requisition at page number 87. By 6 ward members. Page 87. Here the proceeding which has culminated starts from page 87, culminated for the purpose of this writ petition. To the chairman, convening of special meeting under section 28. It is signed by more than 3 ward commissioners. So therefore, in terms of section 28, my lord.
Yes.
In terms of section 28, I am duty bound to call a special meeting, my lord, within 20 days. Now, at page 88, I call for a special meeting. The chairman, in compliance of section 28. Page 88, I call for a special meeting on 24th of May, 2024. That is, if your lordship counts, my lord, it is within 20 days. On 24th of May, 2024, I have called a special meeting. Now, my lord, on 20th, I have issued this letter on 17th, fixing the meeting date on 24th. On 22 days. Executive officer, my lord, in every municipality, municipal board, my lord, there is an executive officer, is a government nominee who oversees the functions of the ministry.
He's a government servant.
He's a government servant. He's an SCS officer. He uses the municipal pad and everything, my lord. Page 89, my lord. Page 89 to the chairman, Shilapathar Municipal Board, such as such, this is by the executive officer. I read this letter. With reference to subject cited above and letter under reference, I am to remind you that the model code of conduct due to Lok Sabha election 2024 is still in force. Therefore, no meeting of the present nature could be convened at this juncture till 4th of June 2024. Further, the issue of no confidence motion pertaining to Shilapathar Municipal Board under case number WPC such and such is sub judice before the Honorable Guwahati High Court. In view of the above, you are hereby requested to cancel, withdraw the special meeting, which was scheduled, void letter under reference with intimation to all concerned. in pursuance to this letter, my lord, I issue a letter on 22nd, page number 90, cancelling the meeting. Now, then, my lord, on the same day, I receive a pleader's notice at page 91 that I am committing some contempt of court.
Yes.
Now, entire projection is given as if the read court in para 17 has given a positive direction that you go and convene a no confidence motion during pendency of the during currency of the model code of conduct, which is not the case. That is as a general observation of law.
Yes.
Then, my lord, after receiving this pleader's notice, the executive officer clarifies the stand at page number 95, which is self-explanatory, my lord, page 95. The executive officer says, page 95, with reference to the subject cited above, I'd like to inform you that while my letter under reference, I only advise regarding the convene of the special meeting as due to model code of conduct is in force till 4th of June 2024, and for keeping records, no officer, including myself, can join any meeting in connection with Silapathar Municipal Board. There won't be any impartial observer to the meeting. My lord, now they have assumed the role of calling a no confidence motion unto themselves, and the person who have signed the requisition, now they call the meeting at page number 96. My lord will kindly see the date of this. Now this time, the person who have signed the requisition, they are calling it. Page number 96, 27th of May 2024. Date on the right hand side. Now, the last para, my lord, they are calling it on 29th of May. No copy of this letter is given to the MP who is an ex officio member. Now, my lord, with 2 days notice, somehow they want to get rid of the chairman before 4th of June. My lord, I can understand that under section 28, no date is mentioned with regard to when the person who have signed the requisition. But my lord, every provision has to be interpreted in some rational manner, my lord. When 20 days time is given to the chairman, at least you can wait for 15 days or 10 days. They are litigating from December 2023. My purpose is to show, my lord, that that for them June 4th, because they know, my lord, if they bring it after June 4th, they will fail. Now 97, my lord, is another requisition, now this time by the vice chairman on the same date. Vice chairman also writes, ward commissioner also writes, my lord. Now, my lord, this notice at page 97, this requisition whereby a special board meeting was called using the pad of the office of the Silapathar Municipal Board. This is a forged document. In as much as, my lord, the reference number pertains to some other document, the actual document is at page number 98, and we have lodged an FIR in this regard at page 99. FIR against Shormishta Deb, Vice Chairman of Silapathar Municipal Board, and other ward commissioner who are her cronies. Now, my lord.
Yes.
Thereafter, my lord, I again tried to, my lord, mollify the situation on 28th. 29th, the meeting was fixed on 28th. I write to them, and in very categorical terms, I said that I am willing to call it after 4th of June. My lord will see the language of page 100. This notice is to inform you that a special meeting regarding the no confidence motion was initially scheduled by the chairperson on 24th of May 2024. However, in accordance with the with the model code of conduct currently in effect, the executive officer has directed that the meeting had to be cancelled until 4th of June 2024. This decision is documented in an official letter with reference number such and such. In view of the fact that the model code of conduct is still in force, the undersigned was compelled to cancel the same meeting. Furthermore, we intend to call a special meeting right after the completion of the said period after 4th of June 2024. I have never shied off from showing my strength in the house, my lord. Now, my lord, notwithstanding that, on 29th, my lord, they hold a meeting among themselves. No impartial man was there. They take a resolution among themselves, my lord, with 7 ward commissioner. It has to be more than 1, my lord. 14, half is 7.
1 is resigned.
7 plus 1. I have letter to show, my lord, where that person who they are saying has resigned has written to the chairman saying that my resignation is not in accordance with law. I want to rejoin. Neither his resignation was accepted. Now, my lord, on 29th, they take a resolution that that they have lost confidence. The present chairman is gone, is terminated. They write to the deputy commissioner. Now, my lord, if I understand section 28 correctly, my lord, if I fail, now before that, my lord, may I?
Was the provision of the act where this government officer is required to be an independent authority?
My lord, as such state, but my lord, executive, but before that, may I show the model code of conduct, that provision where no meeting can be called off, no confidence motion, that's it. Now, my lord, we'll kindly come to page number 110. There is a notification issued by the Secretariat of the Election Commission of India. My lord, may straight away come to page number 122. Meeting of local bodies, panchayat, municipalities, etc. My lord, is there, my lord?
100?
122.
1.
My lord, is
Yes.
meeting of local bodies, panchayat, municipalities?
Yes.
My lord. A writ petition number such and such, Sujit Roy versus State of West Bengal, was filed before the Honorable High Court of Calcutta, seeking a direction that no meeting of the councillor of Kulti Municipal Board should be held during the period when Model Code of Conduct is in force. The Honorable High Court, by its order dated 11/3/2011, dismissed the petition with the observation that the question would be for the commission to decide, and further directed that copy of the order be communicated to the commission. Accordingly, a copy of the order of the Honorable High Court was referred to the commission. Commission here indicates the election commission, my lord. Number 3, the commission, after considering the matter, decided that there would be no objection on its part to hold of the statutory meetings which cannot be avoided by the municipalities. My lord, statutory meetings which cannot be avoided by the municipalities and panchayats and other local bodies, subject to the condition that no new policy decisions and announcements shall be made in such meeting till the elections are over, and only, my lord, this is and only the decisions related to routine day-to-day management issues and on emergency issues may be taken in such meeting. Subject to this.
No other meeting.
My lord?
No other meeting.
No other meeting. Because no confidence motion is a meeting of a special kind. If meetings of the nature no confidence motion would have been contemplated or conceptualized by the election commission after the direction of the Calcutta High Court, then definitely, my lord, there would have been some indication. It says that subject to the condition cannot be statutory meetings. Now, my lord, somebody may argue that state 2 provides a no confidence motion, therefore it is a statutory meeting. Now, my lord, this statutory meeting is subject to condition, subject to two conditions, that no new policy decision and an announcement shall be made in such meeting. This is condition number 1. Condition number 2, and only decisions related to routine day-to-day management. Routine day-to-day management and or emergency issues. Why, my lord? Because, my lord, in a town, small town, my lord, there some emergency situation may at any time broke out, especially with the monsoon in the corner, my lord, flood, everything. So to tackle, to address those emergency situations, you can hold a meeting, but not to remove a chairman, my lord. All the government officers are busy at election. The MP, MLAs are busy at election. It is not a case where the chairman is shying off from any meeting. The chairman is saying, wait, you could wait since December to, we are in the fag end of May. From December, you have initiated, you have filed 2 writ petition, you could wait till May.
Where is the procedure for voting in respect of these meetings relating to no confidences for chairman? How many members are there?
There are 14 members, 12 elected members, 2 ex officio members. The MLA and the MP, they're by virtue of their position as an MLA and MP, they are the members, ward commissioner in a municipal board, who has a right to vote.
So, in a meeting called for removal of a chairman or a vice chairman, it is expected that all the members are to be present.
Members.
All the members.
Yes. Members
are required to be present.
Now,
For the voting.
14 members are required to be present. My lord, I could not, because, my lord, I filed it yesterday because on 29th this impugned order was issued. Yesterday I filed it, made a mention, my lord. I could not, because, my lord, in a meeting when the house is divided, there has to be, my lord, government representative. Because if your lordship sees the first meeting which the deputy commissioner called, he has given his representative. Now, my lord, and even for normal election also we have election returning officer and other things. Because the parties will take their own side. There has to be some government, some impartial authority. And, my lord, what we are saying is that we are willing to call a meeting. We know, my lord, I'll have to show my confidence in the house of in the floor of the house. I can shy off from this. What I am saying is that MP, MLA, they are busy, they are members, they can vote. Election is, now, my lord, we had election. On 4th, everything will be over. Any date, maybe on 10th, maybe on 11th. Let this court fix a date. But in this manner, if an elected person, they have elected me as a chairman. It is not that I am nominated or I have fallen from some other planet, my lord. I am an elected commissioner of the board. And out of 14, if I go by this input resolution, they are only enjoying confidence of 7. And I have my doubt whether they have taken some signature by force. I do not know. No, there was no impartial person present. What might have gone wrong there in the meeting, my lord? Who knows, my lord? That's my case, my lord. My humble prayer is that, my lord, let the chairman, the present petitioner, remain as a chairman. After 4th, my lord, let the MP and the MLA be free, my lord. Let a meeting be called, my lord.
Yes.
Other things apart, my lord, I'll take a lordship's view again. The order of this court, my lord, in writ petition number 168 of 2024. First, your lordship will kindly come to paragraph 15 onwards.
Where is the order?
Or page 40, my lord.
40.
Yes, 40.
Yeah.
And relevant paragraph 14, page 40. My lord, let me first, my lord, tell. My lord, the requisition was first made by us in December. She would not call the meeting. When we addressed the letter to the deputy commissioner, which is generally done, my lord, but this court this time held that DC has no power. DC will forwarded it. He refused to call the meeting. Then, my lord, what happened on the day meeting was called by Vice Chairman, my lord, 5th of January 2024. She uses the police and the Vice Chairman was picked up. Others were kidnapped and we could not, the meeting could not be held. Now this is explained in paragraph 14 of the. Now we deal with the alleged kidnapping of petitioner 2, preventing the petitioner 1 from attending the said board meeting. Have you lordship got my lord?
Paragraph 14.
14.
Yes.
In this regard, we find that the officer in charge of Silvata PS was well aware that a board meeting of the Silvata Municipal Board was scheduled to be held on 5/1/2024. As per the report of the Subordinate Police, Demaji, addressed to the District Commissioner, right, so dated 8/3/2024. There is a mention in paragraph 2 that thereof that a meeting of Silvata Municipal Board was to be held on 5/1/2024 at 9:45 am. Actually, it was 2:30. There is no document to show that meeting was convened at 9:45 am. Even it is assumed that the meeting was to be convened at 9:45 am, then there was no necessity for the police to have NACA checking made at 3 p.m. and to arrest the petitioner 1 by removing her from her vehicle and to send her to the Silvatra PS. Thus, the entire access was to prevent her from attending the meeting of the board of Silvatra Municipal Board and thereafter to verify her identity and then to have it confirmed that she was the vice chairman of the Silvatra Municipal Board and then to release her. Shows intention on the part of the officer in charge of Silvatra PS to have petitioner 1 taken and detained in police station without first verifying her identity. The said action cannot have the approval of the court and has to be deprecated in a strongest manner as the police personnel had interfered with the function of the Silvatra Municipal Board by preventing the meeting petitioner 1 from the meeting.
This meeting,
yes,
which was scheduled to be held on 5/1,
yes,
was not held.
It was
not
held.
held.
It
Held.
failed.
No,
Yes.
I will let you complete.
No, no,
You say.
sir is asking.
What about after I was picked up, then they, the chairperson and other assembled, only 5 and 6 members. There's some signature force also who are not member of the board also. And they passed the resolution that confidence has been upheld in our favor. That's what we came to in secondary prison. Now secondary prison become infructuous matter in a sense. Then, my lord, the observation of the court in the following paragraph shall not be interpreted to mean that the elected ward commissioners cannot be arrested while going to A. Then paragraph 17, which he has read. Therefore, while initiating a no conflict motion against the respondent 7 is not found to be in accordance with the law, and at the same time, the intervention of the district commissioner Demaji and high-handedness of the police officer of the Silvatra PS cannot be approved. The bottom line is that there is no bar under the Assam Municipal Act to once again move a no conflict motion against the chairperson and the vice chairperson. Such motion is null barred. Now, this writ petition 168 and the pending writ petition came together in the same list. Item are in the consecutive order, my lord. Both are heard together, and the honorable judge was pleased to say that since they have not filed the counter in the second writ petition, will take other days. So this was disposed of. Same day, on 29th of April, both the cases were listed as per the board, court's board. Now, my lord, thereafter, she calls the meeting. She herself calls the meeting, chairperson. Then we give the second equation. She calls the meeting, fixing 24/5/2024, my lord, knowing fully well that that was a government holiday, just to avoid the holding of the meeting, and that she is. And then again, she scheduled it to 26th of May. There was that Sunday, knowing fully well that she wanted to avoid in any case. Then executive officer, my lord, orders that you cancel the meeting. Executive officer in the entire scheme of the Municipal Act, my lord, there is no role except under section 53 and 60 and 61, so our financial matters are concerned. He cannot order for it because it is an independent body, my lord. The war commissioner in a democratic manner will decide, not the government officer cannot interfere. If the vote has held that deputy commissioner has no power even to forward the letter of no confidence, then executive officer, how he comes? Yes.
Yes.
Then we, since she failed to call the meeting and within 20 days, then on 27/5/2024, we called the meeting at page 96, fixing 29. The chairperson was present in the office, my lord, in her room. But she didn't attend the meeting when the meeting was going on.
So now in view of his submission that in view of this model code of conduct,
No, mode of code of conduct, I am coming, my lord.
now is there in the presence of an independent authority or
No. Nothing. Yours may go through entire municipal act. There is no role of any independent, in the deputy commissioner, there is no role. Except
in the earlier elections, what happened?
in earlier election, my lord, early election is,
Elections of chairman or vice chairman,
there are 7 members elected.
huh?
7 members
Was there
elected.
any independent member present?
Yes. There were government officers, there were representative of the deputy commissioner, that minute is there.
That is even not called for, but
Minute is
they, DC deputes them.
Somebody has to give a report that it was held, conducted
as per law.
Now coming to code of conduct, that is not required under the law. If DC asks somebody to attend, they will attend. Exit officer only under section 53 and 6061. Here is what the rules for financial matters and schemes are to be announced. That is there. And the executive officer are also written. He comes to office daily, but he said, I cannot be present. Today also in the office. We took our charge today. We intimated him also, he was in the office, and also deputy commissioner, district commissioner. Now let's finally come to page 122, which is read. The Calcutta High Court judgment.
Where is the order? Where is the minutes of the
Impugn minutes, my lord, will see 122.
Huh?
No,
Not 100.
no.
There is a
102, 102.
101.
101 starts. That is the communication is 101 to the deputy commissioner, but the minutes is at 102. Signed by only 7 persons. There's the word commissioner.
7 is majority now. Under 4 is the resolution order. And it was communicated to the under section 47 to Director Minister Administration, Commissioner and Secretary, Government of Assam, District Commissioner, Executive Officer, all ward commissioners, office copy. Duly held, as per law.
Yes.
Now I'll also kindly come to 122. The model code of conduct. In the model code of conduct, I have gone through entire. Since the petition itself was served at 12:30 to me.
Now who is the chairman now?
Now I am functioning. I have taken up charge today from today.
No, my lord, I am the.
Where is the resolution for you to take charge?
My lord, after the year they elected me.
Where?
In the resolution, there is nothing of that sort.
Where?
Absolutely nothing.
Under 4. They have a revision. I am told them I have got a specific instruction. They have elected.
It has to be reflected in the minute.
I think that is separate system.
How?
It may be. Even next date also, but third date also it will be done. They have done it.
Your municipal
Yes.
as the chairman and the vice.
Yes.
So you have taken a no confidence against the chairman.
Yes.
Chairman is terminated.
Yes.
Now what happens to the vacancy?
Vacancy either vice chairman will run. If the person is not elected then on the same meeting, It will be elected subsequently also. Vice chairman function
Where is the decision?
to function for the vice. I think it is authorized by the law.
Authorization law is different. But in a meeting,
Yes.
holding the no confidence of the chairman,
Yes.
there has to be a decision that will.
Malik, can it be taken at
Vice chairman is now-
3:15? I will get the instruction in the copy if there is any.
Huh?
At 3:15.
3:15.
Let it be taken at 3:15. I am calling them to send the decision immediately. Because they have already intimated the deputy commissioner and others that they have taken charge. Jitin Payang has taken charge and functioning. So Jitin Kutim.
Then Pang is our secretary.
Bar secretary. And she has been avoiding Mali since December.
Whatever it may be,
Yes.
that's a different issue.
Yes.
The question of whether subsequent meeting can be called if permitted, then whether it is valid, if it is permitted, is one aspect.
Yes.
The other is once you have called a meeting,
Yes.
correct or incorrect, you have taken a decision to terminate.
Yes.
Now, after termination, what happens?
That I will get. Now, holding the meeting is permissible under section 43. After 20 days.
That will decide whether it was necessary to hold the meeting,
Yes.
because the 122 says ordinarily day to day, and such other emergencies.
No, my lord. 120, let me read the third paragraph.
122, page number 122.
Yes, I am reading a third paragraph.
Third.
First, the Calcutta High Court dismissed the petition and leaving it to the Election Commission. Third, the Commission, after considering the matter, decided that there would be no objection in its part of the holding of the institute meeting. Section 28 of the Municipal Act institute meeting, which cannot be avoided because it was already called by the chairperson earlier, and there it is a follow-up of that. Ever by the municipality and panchayat.
When it was called, there was also the this code of conduct was enforced.
Initially, it was in December. So, in the, if I am to take my lordship through the entire scheme of the model code of conduct, running work cannot be stopped. If that is implied, my lord, then even a court proceeding cannot run. It is legal proceeding. It is a legal proceeding that has been initiated earlier.
Legal proceeding is a different issue. What we are trying to understand is,
Mm.
you have to show the reasons why the meeting was so urgent that it has to be held now. What was the necessity?
First thing, my lord. First thing.
We are not questioning your powers to convene or call a
Yes,
meeting.
we have power to convene and hold the meeting and.
Number 2, section 53.
Yes, 43.
53.
43.
So section 53
Yes.
talks about the executive officer.
Yes.
The executive officer will be responsible for any act or omission.
Yes.
Or commission.
Yes.
Of the municipality.
Yes.
So, how can you say that the executive officer has no role to play?
So far as the no confidence matter is concerned,
Not in the meeting, but in the conduct of the proceeding.
conduct of proceeding also has no role because section 28 does not emphasize that, nor section 43. He has got day-to-day functioning of the municipality. He supervised the work of the municipality.
No, you see 53(2).
Yes. The executive
He
officer
shall
shall function under the overall control of the board and under the direction of the
What is the meaning of overall control of the board?
overall control of the board. But overall control
Overall control of the board and under the direct supervision of the chair.
chairman. He shall be further subject to direction issued by him to him by the director of the government, all financial matters, particularly those relating to implementation. So here mainly overall function of the board he shall. But holding of special meeting or not holding a special meeting, it is not within his domain. And even this code in 168, which I have read, and Mr. Banik also read, that there is.
But in any event of the matter, there, the minutes does not reflect.
That I will just get.
There is nothing in the
We can't wait for the instructions to be. You get it. You place it before the court.
Hello.
Or you place it before the court on the next day. Whatever instruction they want to place it.
My lord, we have
And
already.
you don't caveat.
Yes, we have already discharging functions. And there is no law,
We are asking
one
you-
more thing, one more thing.
But we are asking you, how are you discharging your function unless there is a resolution to that effect?
Yes.
You are the vice chairman.
Just now within 10 minutes I'll get mine.
10 minutes. What are we supposed to do? 10 minutes. You place
I
it
have
before the
especially
court.
told my lord
You
today.
place it before the court on 5th. 5th. Till then, don't give effect.
No, distance go measurement.
Whatever, status quo, whatever. Not
Yes,
status quo, you don't give effect.
Okay, distance go measurement.
Not
Because already-
status quo.
Hello?
Not status quo, don't give effect to this resolution.
Go on. Go.
And we'll also direct the petitioner not to take any decision with regard to any policy.
Yes, yes, we are
Any
not,
policy matters, no decision.
will not take, will not.
My lord, there is a huge swindling of fund by her, which we have mentioned in
Not to
the.
take any policy decision, not to operate the funds. Till the next date fixed, as the chairman.
My lord, will not take any policy decision fund also, but my lord, this order may be a predicament for day to day. You get some rider.
What day to day?
No, they-
what day-
Electricity, suppose my lord, in a town.
You come and trouble the court again.
My lord,
Seek a modification of that
my lord, because of cyclone, if
There is an order of, there is an order by a group of persons against you. You have lost the confidence.
Yes.
Question is whether it was correctly done or not. We are examining that. But fact remains that there is a decision taken against you.
Under
There
the
is a
scheme of the
decision
act.
taken against you.
My lord.
Whether that decision is capable of being implemented, not implemented, procedure maintained or not, is a different issue. So while we examine you.
My lord, my bona fide, for the purpose of bona fide, your lordship, whatever condition your
That's
lordship
right,
is,
we are
my only thing is that, my lord, so that, my lord, because, my lord, I have been, the standing council of Dhemaji Town Committee also, a situation once arose, my lord, at night, few electricity, and
Okay,
because of lightning.
executive officer will do it.
Because of lightning, my lord, at night, my lord, 50, 60, these street bulbs got fused, my lord. So in such an emergency situation.
Heard done it, council.
Executive officer is there for overall control of the board.
And this was also heard Mr. R.P. Sharma, the senior counsel assisted by MS so-and-so. Iteka appearing for respondent number 6.
Yes.
6. Who is on caveat. MS Purwa appears for respondent number 1, 2, 3. And 4 also. Executive officer. The petition filed who was the chairman of Silapotar Town Committee.
Municipal board.
Silapotar.
Yes, Silapotar.
Municipal Corporation. Municipal
Board.
Post office and police station, Silapotar, district. The petitioner is aggrieved by.
No, the other, for others notice will have to go. Why am I waiting for
We'll
that?
issue notice. The petitioner has questioned the minutes dated 29.
Yes.
29th of May. Held in an emergent meeting called for by requisitioning for called on requisition of certain members for deciding the issue of no confidence motion against the petition. So, learned counsel for the petitioner submits that by the said emergent meeting, the no confidence motion was initiated and the petitioner and a resolution was adopted to the effect that the petitioner was terminated as the chairman of so-and-so. He submitted that this no confidence motion is contrary to the provisions of the Municipal Act and also the Model Code of Conduct. So, the counsel for the petitioner submits that there is no dispute on fact that the model code of conduct is force till 4th of June when the results are scheduled to be declared. So, referring to the model code of conduct submits that so far as the municipal board and town committees are concerned, as per the views of the election commission, only matters relating to day-to-day affairs of the committee and on emergency issues can be taken in meetings. No policy decisions and announcements shall be made in any such meeting till the elections are over. Stop. Referring to the section, what is that section?
247.
47. Learned counsel for the petitioner, 247 of to employ. Learned counsel for the
247. 297. Oh, sorry, 297.
297 of the Municipal Act submits that emergency meetings, emergency defined under section 297.
I think this is not applicable, madam.
It says submission, we are recommending. Submit that what is emergency would be decided in respect of matters which are only for the concern of health and safety of the public, as and when the of the locality of the jurisdiction of the court, under the jurisdiction of the court. It submits that in the area concerned over which the board has the jurisdiction, if there is any emergency concerning the health and safety of the people therein, and a meeting to that effect is held, only that circumstance can be called an emergency meeting. However, save and except those emergency meetings and day-to-day affairs, no other meetings can be held in view of the currency of the model code of conduct. It refers to a communication dated where is that executive officer's letter?
Oh, that officer's letter, my lord. That officer's letter, your lordship will 89. 89.
He refers to the communication dated 20 May 2024, addressed to the chairperson by the executive officer, stating that the no confidence motion pertaining to the Silapota Municipal Board should not be held in view of the currency of the model code of conduct for Lok Sabha election 2024, as well as the matter being sub judice under the High Court, sub judice in High Court by way of WPC 156 of 2024. Stop. Learned counsel for the petitioner submitted that there is no difficulty in holding the meeting, save and except the restrictions which have been imposed by the model code of conduct as well as by the says the meeting of this nature can be held immediately after 4th of June when the results are declared and the total loses its effect. However, notwithstanding these conditions, the respondent number 6, who is the vice chairman of the board, along with 6 other members, initiated the no confidence motion and proceeded to hold the meeting on the ground that the chairperson failed to conduct the meeting, and in terms of section 28, the requisitionists are required to hold the meeting. And the and the meeting was held, resulting in the resolutions adopted against the Departmental. Therefore, submit that the urgent orders are required for this court, calling for interference of the resolution adopted against the petitioner, and during the pendency of the petition and when interim orders be passed. Para. The learned senior counsel, on the other end, strongly disputes the contention of the petition. He submits that there is no bar, no bar can be inferred from the model code of conduct, and there is no role of the executive officer save and except the supervision of the day-to-day affairs of the municipal board and matters with regard and financial matters relating to the municipal board. Insofar as the motion of no confidence against chairperson or vice chairman is concerned, the mandate of section 28 today. Under section 28, the requisition is to be given by more than half the number of members of the Silapur Municipal Board. There are 14.
Yes.
14 members. And how many had
So
requisition?
one is resigned, my lord. He is not attended also.
So there are
13.
Subsequently one person has resigned, and at present there are 13 members. Out of 13, how many had requisition?
7.
7 members.
Now 7 present.
The requisition is 6, voted 7.
7. 3 can requisition, my lord.
3 can requisition. For requisition,
As per the provisions of the Act, only 3 members are required for requisitioning. However, the resolution is to be passed by not less than more than half the members.
More than
stop. Under such circumstances where there are 13 members of the municipal board present, 7 members have voted in favor of the no confidence motion against the petitioner, and thereby thereby passing the resolution that the no confidence motion against the petitioner is approved, and consequently the petitioner is terminated as the chairman of this way. He therefore submits that there is no information in holding the no confidence motion as well as the resolutions adopted. The senior counsel further submits that at present the petitioner, the private respondent number 6, he is functioning as the chairman. So what instructions have come?
My lord, he is going to contact the chairman. Vice chairman.
Well, having heard learned counsel for the party for their consideration of the materials report, it seems that by the resolution adopted on 29/5/2024, the final resolution, there were 3 resolutions adopted. The resolution number 1 is that the petitioner, the chairman, failed to convene a meeting scheduled on April 6, 2024, and thereby exceeding the stipulated period of 20 days, and consequently the vice chairperson has assumed responsibility and presided over the special board meeting regarding the no confidence motion. The resolution number 2 is that the chairman be terminated by a majority vote of 7 ward commission. Resolution number 3, that the proceedings of the special board meeting shall be forwarded to the relevant offices, namely Director of Municipal Administration, site of page 104, 1, 2, 3, 4, 5, 6. The resolution also reflected that as per notice dated May 23, 2024, the meeting could be conducted during a no confidence motion even in the absence of the executive officer. Stop further. The assertion that the meeting could not be conducted due to model code of conduct was deemed illegal and unacceptable. The final verdict / resolution adopted in the special meeting is as under 105 tick, tick, huh? 105 etc. Having carefully perused the resolutions adopted and also taking into consideration the submission of the tribal sub council, and see that prima facie a resolution has been adopted against the petitioner, voting her out of the office of the chairperson / chairman. So, whether this meeting was convened and was conducted as per the provision of law or end of legal in conflict with the mandate of the code of a violation of the model code of conduct is an issue which will require execution. But prima facie, it appears that there is no resolution adopted permitting the respondent number 6 to adopt to function chairperson in the place of the petition. Stop. It has not been placed before the court that any decision has been adopted in the
But I got instruction.
adopted in the meeting that a subsequent election is required to be conducted shortly or already has been conducted, electing the respondent number 6 as the chairperson in place of the present petition. So, yes, what instruction?
That already there was a meeting, my lord, but the chairman has gone to DC office now. He could not be contacted. Chairman now, present chairman could not be contacted. He has gone to DC office. Vice President, resolution has been taken.
That is not here.
Yes, not here. They have not done next week, but because we are arguing on that document.
In rejoinder, Mr. Harti Sharma, that is the council, 6, submits on instructions, verbal instruction, that there is a further resolution to that effect that the respondent number 6 is to be permitted to operate as the chairperson in place of the present petitioner. So, however, no such copy of the minutes or resolution adopted in court at this stage. Under such circumstances, to the view that at this stage, the notice be issued, returnable 4 weeks. Mr. MS Deka accepts notice on behalf of the caveator, respondent number 6. Stop. S. Borua for respondents 1, 2, 3, 4. Steps on respondent number. So you are accepting notice on 5 and 6. Vice Chairman and
6 to 12 probably.
No, I have not. I have filed a debate only for 6.
For 6. But 5 is the Vice Chairman. So notice will go.
Notice will.
Notice be issued on respondent 5, 7, 8, 9, 10, 11, 12 by usual course and registered post. AP. Matter be until further order, the resolution adopted insofar as termination of the petitioner as chairperson will not be implemented without leave of the court. Stop. It is also made clear that the petitioner, it is also made clear, notwithstanding the order passed as directed above, the petitioner will not assume the office of the chairperson to take any such policy decision. The meeting or
On any financial matter, my lord. Actually, executive officer can function so far, our under section.
in any financial matter, save and accept those matters where she's a save and accept where the participation of the petitioner is necessary as a joint signatory along with the executive officer of the municipal board. Stop. Matter be listed after returnable date. Yes,
Any date, my lord. Will file counter.
we take steps.
Yes, yes, I'll take.
Dusty is also perfect.
Yes, that's the.
10th of return with 10th.
We had given you 4 weeks, we'll reduce.
Okay,
it
I'm
to 2
happy.
weeks. We can reduce it to 2 weeks if you want.
No. Okay, no plan.
You want 4 weeks.
I'm alive.
My lord, I'm just receiving instruction, which I can accept notice for the private respondents.
You can accept.
Yes,
Are you sure?
yes, yes.
That is what I'll say, 6 to 12.
Mr. Dole accepts notice on behalf of
6 to 12.
6 to 12. 5 to 12. 5 to 12. Then you write that registered since Mr. Dole accepts
My lord,
steps, extra copies be furnished. Notice is the way, but extra copies be furnished within a period of 1 week.
can you do fixed date, my lord? Short date, I'll file between my return.
21st June.
Shorter than that,
Shorter.
because it is a simple matter, our lordship could dispose of for that.
14?
Yes,
14 June.
yes,
Return
obligation.
notice on stay prayer. Return of the stay prayer.
I'm deeply obliged.
Weeks time. Lordship, 2 weeks time may be granted to file the affidavit.
Reply affidavit.
Yes, your lordship.
Petitioner proceeds for further time to file week's time, file reply affidavit. Prayer made is allowed. MS. Your
K. Bhattacharya. K.
K.
Bhattacharya.
Bhattacharya appears for the applicant and then Purva for the respondent. After.
My lord, I'll see the last order. Here, the Muslim Marriages Act 1935 has been repealed by the government. It is under challenge before the division bench, and matter is fixed on 26/6. So any day after that.
It is submitted by Mr. M. Mohammed that the ordinance, the Assam repealing ordinance 2024, by which the Assam Muslim Marriages and Divorces Restriction Act 1935 has been repealed under challenge before this court. Do you have the writ petition number?
Petition number. Perhaps it is the last order.
In WPC, yes, WPC number 163 of 2024. Stop. It is submitted. That matter is fixed on next date fixed. The matter is 26th of June. Stop. According, let the matter be listed.
Let it be
on
26.
22nd of July.
2nd of July.
22nd of July.
22nd, my lord. It's 24 of June, it is fixed. Some address is there. He is a CRPF personally. Let it be the last day of this month.
When is the matter fixed?
24.
24th of June. Matter be listed on 26th of June. Yes. 26th of June.
Please, my lord. Pursuant to the last order, my lord, we have filed our affidavit of service. Respondent 124 have entered appearance by filing their wakalnama, and respondent number 6, my lord, they have refused to accept the same, my lord, and that we have categorically stated in our affidavit, my lord, in para 4.
Who's respondent six?
Respondent six is the matter L1 bidder, my lord, is the private respondent, my lord.
The contract has been awarded.
Yes, my lord. We had a L2 bidder, my lord. 60% has been awarded to them, 40% to us.
You're who's for the IOC?
I am for the respondent number 1, 2, 3, and 4.
IOCL.
Yes, Lordship, Bongaigaon Refinery.
What do you say?
Because I am instructed to appear only for 1, 2, 3, and 4. Lordship.
For five.
I will lord the Union of India, my lord.
It is submitted by the council to the petitioner that steps on respondent six by way of custody was sought to be undertaken. However, custody apart from registered post. However, as per the affidavit of compliance filed by the petitioner on 2nd of May 2024, there is a categorical averment. The respondent number six refused to accept the notice. Accordingly, if the matter be listed for admission. The you have taken post, you have taken service by registered post,
To Dusty, my lord.
not registered post. Huh?
No, my lord.
Why? You have been directed
Yes,
to
my
take registered post. You write in the office note reflects that notices by registered post on respondent 1 to 6 has also been issued. However, service report is not complete. Registry to make necessary endorsement and list the matter after 2 weeks.
Lordship, extra copy
Meanwhile,
may be served upon
MS Kakoti.
R. Kakoti.
R. Kakoti appears on behalf of respondent 1, 3, 4, 5.
3, 4,
Huh?
not 5, Lordship.
1, 2, 3, 4.
Yes, Lordship.
Learned CTC appears on behalf of you. Extra copies on the learned council be furnished within a period of 1 week. Matter be listed up.
My lord, we'll take place test upon the respondent number 6 for registered post.
You have already taken?
Yes, ma'am.
Here in this case, Lordship, we have to file an affidavit, Lordship, on behalf of correspondent 2, 3, 4, and 5, Lordship. I place for some time, Lordship. And if it's the matter after 2 weeks, Lordship, I will file the
Yes, any
affidavit, Lordship.
objection? Heard Mr. Ekasai, Mr. J.K. was on the cabinet state, raised for it in rapid weeks further time to fight response. Rare, not rare waiting allowed as just after 2 weeks.
One date, my
After 2 weeks, let it come in July.
Lordship.
On a date to be picked by the region.
Do please.
Yes.
May I please, Lordship? Lordship, we kindly see the office number 30.
Huh?
Yesterday, officer, my lord. So far as respondent number 7, 10 to 16 is concerned, my lord. Flower Cinema Court directed to take steps. Again,
Fresh steps. You have
fresh
not taken.
step. Yesterday's order, my lord. This order.
So you want to take.
May I pray for, instead of so district as, may I pray for Dusty? As well as register.
Already an order has been passed.
In addition, Dusty may be included. It will be more convenient.
Heard. Petitioner craves for some time. Takes service, further time. Complete service on respondent. 7 and 10 to 16. In terms of the order, dated 21/12/2020. So it is further submitted. Counsel for the petitioner further craves leave to take service on respondent 7, 10 to 16 by Dusty to bid to the office. Where made is allowed, petitioner may also, in addition, take service by way of Dusty, respondent 7, 10 to 16. Mr. Talukdar, appeals for
I'm for 1 to 4, madam. 1, 2, 3, 4.
1, 2, 3, 4.
I am appearing for 8 and 9.
Mr.
Kemalo.
Kemalo, appeals for the respondent 8. Respondents are permitted to file a counter to advise in the meantime. Please,